Good morning, ladies and gentlemen. My name is Mark Valash, and I'm a Deputy Secretary of State for Elections. Are you able to hear me all right?
Yes, we got you.
Excellent. Perfect. Thank you. So I've got 7:55. We'll give it a few more minutes. I suspect there'll be more people joining today. I'll plan on turning my camera back on around 8 and then beginning the proceedings probably a minute or two after. Historically, we started right about 8:04, 8:05 period. But I'll be here. Thank you, though.
Can you use that first? Well, we're not getting there. All right.
Good morning, ladies and gentlemen. My name is Mark Voloshin. I'm the Deputy Secretary of State for Elections. I have 8:01. I do understand that there's a handful of other folks that are still planning on joining, or it looks like they're trying to join right now. So I'm going to do them a favor and give them a few extra moments just to make sure that they're able to participate in this event today. I do appreciate you joining me. Again, this is an adoption hearing, and I'll get into the details here in a few moments. Yeah, that being said, I'll give them just a few more moments to let everybody join, and then we'll begin. Thank you. Okay, good morning, ladies and gentlemen. I have 8:04. It does look like there's still some more people joining, but in the interest of respecting your time, we will go ahead and start the proceedings today. First and foremost, my name is Mark Voloshin. I'm the Deputy Secretary of State for Elections. I work directly for Secretary of State Barbara Sagaski, who again is ultimately the originator and director of this process for us to conduct a regulations review. We'll get into a little bit of the background on why we did this and what the intent was. But first of all, I'm calling this hearing to order, this adoption hearing to order at 8:05 a.m. For the record, I'm Mark Voloshin, Deputy Secretary of State for Elections, and I will be conducting this adoption hearing today. Before we begin, I want to clarify a few things. Our discussion today during this adoption hearing will be focused on the proposed regulations listed in the agenda. We should not discuss changing statutes, which of course are created by the legislature. This regulatory process will not alter any existing laws. This adoption hearing is not the end of the regulations process, nor for that matter was it the beginning. Following the completion of this adoption hearing today, the next step is the Legislative Commission on February 28th at 1 p.m. I'm copying a link into the chat right now that will take you to the Legislative Commission website that will provide the meeting information when it is available. There it is. Regarding the adoption hearing today, and as a reminder, there are 3 ways to indicate you wish to make a public comment. Click on the raise hand icon in the Zoom bar at the bottom of your screen or on your phone. Physically raise your hand to show that you have something to say or to state in the chat that you would like to make a comment. If you do that, I'll call on you, and that way you'll have your 2 minutes, so that way you can make the comment as well. If there are general questions about elections procedures, I'll be able to discuss them as long as they relate to the proposed regulations. If there are questions that extend beyond the regulations on the agenda, I would be more than happy to set up a separate meeting at another time. To do so, please contact me at nvelect@sos.nv.gov. I will copy that email address into the chat as well for everyone's awareness. Finally, participants in this adoption hearing are reminded to treat one another with dignity and respect. This does include in the use of the chat today. This is the adoption hearing for the Secretary of State's Elections Division's proposed regulations with the following LCB file numbers: R099-21, R100-21, R101-21, R102-21, R103-21, R104-21, R105-21, R106-21, R107-21, R108-21, and R109-21. The draft of all proposed regulations has been provided, as are all the statements required pursuant to NRS 233B.0603. A notice of intent to act upon a regulation was noticed at all required locations on December 30th, 2021. A workshop was held to solicit public comment on January 20th, 2022. Since then, the Secretary of State has continued to receive written feedback relating to the proposed regulations that we will discuss today. I will address some, but not every one of the proposed suggestions and comments received. Some of the suggestions have been incorporated into these proposed regulations. In those cases, the amended text will be described, but the final version of the text will be available prior to the Legislative Commission on February 28th. And that's something that's important that I want to draw attention to. In the agenda today, you'll notice that the text in the agenda is the same as from the workshops. So I will address very specifically the changes that we are going to adopt prior to the adoption for each one of these. So there were some written comments even as recently as just this morning expressing concern that nothing had changed. Things have changed, and we will address those in a very clear and concise manner today. Again, in those cases, the amended text will be described, but the final version of the text will be available prior to the Legislative Commission, which has now been scheduled on February 28th at 1 p.m. Other suggestions that we received will require further research and analysis over the coming months, but may be considered for separate regulations following the 2022 election cycle. Some suggestions conflicted with existing statutes or exceeded the scope of these regulations and were not considered. Finally, the Secretary of State had a number of requirements to weigh in the considering of the provided public comments. These proposed regulations were drafted in order to, 1, update the regulations as required by NRS 233B.050, 2, to clarify expectations for the clerks and registrars, and 3, to increase transparency for the public. While many of these proposed regulations create additional requirements for the clerks, registrars, and the Secretary of State's staff, it is important to recognize that the work required by our state and county election officials has increased in the last few years, and there are no real good metrics upon which to base future requirements. The 2020 election cycle was unique and had a number of factors that directly affected voter outcome and clerk and staff requirements. Many of the issues present in 2020 are not the same in 2022. For example, the state received $4.5 million in CARES Act funding to support the additional needs of the 2020 election cycle. Those funds are no longer available. Therefore, we do not have a clear precedent to look to for future election cycles. Altering these proposed regulations to make them more stringent or to increase the requirements could make them impossible to accomplish. Therefore, in many cases, we are moving forward with these measured, reasonable improvements, but with an eye on future modifications that will be based on lessons learned during the 2022 election cycle. Agenda item 2, public comment on matters other than the previously listed LCB file numbers. Comments will be limited to 2 minutes per person. At this time, is anyone interested in providing public comment about a matter not already on the agenda or discussed earlier? If so, please identify yourself And again, this is a continuing theme throughout the morning or day. When you do come up for public comment, again, indicate in one of the 3 ways that I asked before, please. And then when it is your turn, please, again, state your full name. I may ask you to spell it if you haven't already updated your name on your Zoom camera so that I can just copy it from there. At this time, though, is anybody interested in providing public comment? Ms. Thomas, good morning.
Good morning, Tracy Thomas for the record. In the interest of productive commentary, it would be prudent to clarify that the NAC are merely regulations coinciding with the NRS in how those statutes are to be applied and enforced. These regulations are not creating new laws, as some have been led to believe. This forum does not have the power to change the laws passed last year, such as mail ballots, electronic voting, early voting, voter ID, etc. Those appeals were submitted by many last year with much frustration due to the Democratic-controlled legislature. Comments relating to such items should be reserved for next year's legislature sessions. It is not that this body doesn't recognize your concerns in these areas. It is that it doesn't have the power to change them at this time. NRS 293.124 affirms that this agency is responsible for the execution and enforcement of the provisions of Title 24 of NRS and all other provisions of state and federal law relating to elections in this state. As such, any and all references to person must be corrected to citizen, as is directed by Title 52 of the United States Code, Section 10101, Item 1. All citizens of the United States, NRS 293.485, qualifications to vote, citizenship. Item 1, every citizen in the United States. Any person cannot participate in our election system. Only citizens are legally allowed. The Deputy Secretary of Elections stated on April 13, 2021 at a Washoe County Commissioner meeting that this agency is not currently verifying citizenship of applicants registering to vote. This would imply that this agency is conscientiously neglecting to enforce the qualifications to vote defined in regulation of NRS 293.485, as well as their own regulations, NAC 293.270, which states in item 3 that a county clerk shall count a provisional ballot if the clerk determines that all the requirements were satisfied by the date of the election, which underneath item B specifies the voter was a citizen of the United States. So not only is this body mindfully neglecting Nevada law, they are choosing not to enforce their own regulations. Thank you.
Thank you, Ms. Thomas. Mr. Parks, good morning.
Good morning, Mark. Bruce Parks, Chairman of Washoe County Republican Party. I have a concern with the opt-out option. Will the Secretary of State's office adjust the printing of mail-in ballots based on the number of persons that opted out of receiving mail-in ballots, or have they already projected to print X number of mail-in ballots, and then regardless of how many people have opted out, mail out all those ballots to the folks that didn't opt out and hold those other ballots in reserve? How exactly is that going to work? I understand that it's up to each county to print their own ballots. However, will guidance from the Secretary of State's office influence the number of mail-in ballots that are printed? The concern is that if a significant number of people opt out of receiving a mail-in ballot, but yet those mail-in ballots are still produced, where are they going to go? Thank you, Mark.
Yes, sir. Thank you, Mr. Parks, for your comments. And to clarify, and I think you are on the right track. The purpose of the opt-out process, especially the deadline, right? You have to opt out prior to 60 days before the election, is specifically to prevent the creation of the ballot for those individuals. That is something that, again, is universal across the 17 counties. So it's not that when you opt out, we're going to print a ballot and then hold on to it. it's very much your name will come off of the list before it is sent for the creation of those ballots. But thank you for the question and comments. Ms. White, good morning. Ms. White, good morning. Do you have a comment?
I'm sorry, getting started. I don't know if I heard you correctly. Did you say that any of them, that all of the modifications and edits that you made based on the last workshops are not represented in these documents that are in this link, this notice? And where can we see those modifications other than just now? It would have been nice to have them before so we could compare and be ready to talk about them. Thank you.
Yes, ma'am. No, that is correct. Again, we were working and continuing to consider comments that we received even as late last night. So it unfortunately would have been possible to provide them. When we discuss them today, we will again provide some very clear a clear explanation of what changes are going to be made. But again, this is not the, like I said before, the finish line. The revised text will be available for your review prior to the Legislative Commission on February 28th. So while today I'm going to explain in very clear detail for you as well as for the record what those changes will be and which of the suggestions that we've incorporated into the text, the ultimate final text again will be provided prior to Legislative Commission.
So we will not be able to see a red line version of what you're going to do, except maybe 72 hours before that February 28th meeting.
I'm not certain when they will post that in advance, but it's our intent to get it turned around as quickly as possible following the adoption hearing. And again, today, like you'll see the first regulation on the list. I think is actually the fourth one down that has changes based on the public comments and some of the other feedback we received. You'll see the level of detail that we go into. Again, this is being recorded. We'll have the link posted so that anybody that does have questions will be able to revisit it later on. And then in regards to the updated text, we will certainly get that out as soon as we can.
I appreciate that. Just off the top of your head, if you're able, can you tell us how many of these, just for today's meeting, how many had edits?
Yes, ma'am. 1, 2, 3, 4, 5.
Okay, thank you.
Yes, ma'am. 5, absolutely, for today. Ms. Crump, good morning.
Good morning. My question is, the opt-out ballots, we know we have people that have moved out of state. We know we have people who have died and are still on our voter rolls. We know we have a whole lot of people that have registered their residential address to be at vacant lots. What is the opt-out method for those people?
Thank you for your comments, Ms. Crump. To clarify, so there's a number of things that we do to maintain the statewide voter registration list, which is, I think, kind of the crux of your question. It starts with any official elections mail that goes out across the state. Again, individuals may not realize it, but I always want to take a chance to remind folks that if you receive or see a ballot or even a postcard that comes to your house that was for a previous tenant, or if anybody sees that, the wrong thing to do, interestingly enough, is to tear it up. The correct thing to do is write return to sender on it and send it back, or if you'd rather, hand deliver it to the county clerk. Say, this is your address. You received mail for a previous tenant. It's a postcard. It's official elections mail. By providing that back to the clerk or registrar, that starts the clock to inactivate that individual. So again, it doesn't mean that they can't vote, right? Because if someone moved from one neighborhood to another, one county to another, they have the ability to register at that other location. But the list maintenance procedures and steps that we're taking to keep the lists cleaner than they had been in previous years are ongoing and continuous. So that's something that the clerks and registrars are working on. That's something that the Secretary of State and her staff here are working on. But again, there's an interesting role that voters take in that process as well. An important one in regards to providing that official elections mail back to the registrars.
We know that Eric failed to remove people living in vacant lots and claiming that as their address. So we know if Eric is the only system actually employed, that we have huge gaps now. And what is the Secretary of State's office doing to address the gaps that Eric is not addressing?
Appreciate the comments, Ms. Crump.
Nice horse, Kathy.
Someone needs to mute, please. Thank you.
The bottom line is that I think there's a lot of misinformation
The
out
bottom
there
line is
about,
my nuts.
about what ERIC actually is and what it does, and what it doesn't do, frankly.
Eric does my nuts.
And there are a number of other processes that we have in place that are daily activities that help support the voter registration list maintenance. As that's slightly out of the scope of the regulations today, though, again, I would love to sit down with you and talk about the extensive, and that's like easily a 2 or 3 hour
I'd love to talk about
conversation.
my nuts, bro.
Yes, the data we've mined does suggest that Eric is malfunctioning. And yeah, that would
Eric's
be,
malfunctioning on these nuts.
I'm going to mute myself, and I don't know who else is up there, but maybe we should mute everyone and start again, eh?
Yes, ma'am. No, I see it. There's an individual on the call, Peter, who, let me see if I can.
Stuck my nuts, Mark. You got this.
Thanks, Peter. Take care. Okay. Apologize for that, ladies and gentlemen. Okay, but Ms. Crump, yes, please. Eager to talk about again the voter registration list maintenance. To just discuss ERIC. Again, we were one of the founding members of that organization, and who pays for it and how it works.
Thank you.
But yes, ma'am. Absolutely. Is anybody else have Ms. White, do you have an additional comment, or is that from before?
Well, thank you. Sorry, I'll put it down.
Okay, thank you. Yes, ma'am. Okay, I don't see any other hands raised. Then at this time, we will close public comment on matters not listed on the agenda for the and move on to the regulations. It is noted that for the record, the regulations will be addressed one at a time in numerical order. Public comment will be taken in the same order, and public comment will be on a particular regulation will be closed before we move on to the next one. Before public comment is opened on each regulation, I will read into record a summary of the changes that again, as originally amended, as well as any changes that have come up since the workshops, and again, as recently as yesterday. Okay, to start with then, we will open the adoption hearing regarding the proposed amendment R099-21. Okay, proposed regulation R099-21. Existing law, make sure I'm not on mute, perfect. Existing law requires each county and city clerk to send certain registered voters a mail ballot for every election. The county or city clerk is also required to enclose a return envelope with a mail ballot that is sent to a voter. This regulation requires each county and city clerk to, 1, submit to the Secretary of State request to use a unique color for all return envelopes that are enclosed with mail ballots in the county or city as applicable, and 2, on or after January 1st, 2024, print return envelopes in the unique color approved by the Secretary of State for that county or city as applicable. This regulation also authorizes the county or city clerk to print return envelopes in the unique color approved by the Secretary of State for that county or city as applicable before January 1st, 2024. Following the public comments and feedback that we received, there are no additional changes to this proposed regulation. At this time, is there anybody interested in making public comment on proposed regulation R099-21? Ms. Thomas, please.
Thank you. I just wanted to clarify, is this for the purpose that, so for instance, if somebody who lives in Fernley and actually works in Reno can actually turn in their voter ballot in Washoe County, and then Washoe County will forward it back to Lyon County to be counted?
Apologize for the delay. I'm kind of working on a number of timers and other things and mute. Thank you for your question, Ms. Thomas. The answer is no. Again, if asked, if directed, we absolutely will tell people that you are responsible for putting your ballot into your county drop box and returning it to your county clerk. Again, the mail ballots that are sent out have return postage paid for. So it's as easy as putting it into a mailbox to return it. But if an individual is interested in dropping it, and this did happen, this was one of the things that we found out in 2020. Individuals that, like you say, I think, live in Lyon, but work in Carson City maybe, or in Washoe, and maybe inadvertently, cross the county lines and then drop off their ballot on their way to work. Again, if anybody sees them, this will help, again, reduce the possibility of them dropping that ballot into the wrong box. Again, the vision going forward over multiple election cycles, you could see that if Carson City has a certain ballot envelope, green maybe, or something along those lines, on the box itself, it will say green envelopes only for Carson City. So that if someone's walking up and they have their ballot in their hand and they see that, it will help reduce the risk they're going to put the ballot into the wrong county's drop box. And then similarly, if there is a situation where a clerk or registrar recognizes that a different colored envelope has worked its way into their system, again, they can quickly and timely get that to the right clerk in those rare instances where that does occur. But this is all part of our continuing effort to make sure that things are as easy for the voter to understand. Again, options are there so they understand the right place to put the ballot and not the wrong place. But thank you for your comments though and question. Mr. Kampf, good morning.
Good morning, Mark. Thank you for putting this all together and hanging in there last week. It was a long process. Is this the right time to discuss the type of paper used for the mail-in ballots and to recommend that all mail-in ballots use non-reproducible paper that has a watermark? Or would this be on another section?
This is probably as good a place as any, sir, for your recommended comments. So I'll start the clock and allow you to provide your recommendation. Yes, sir.
Thank you. For the record, Mark Camp, Republican candidate for Nye County Clerk. My recommendation is that the Secretary of State require that all county clerks or city clerks use paper that is non-reproducible on a copy machine, and that it includes specific watermarks and holograms that make that paper unique and not reproducible in any other way. And that's it. Thank you.
Thank you, Mr. Kemp. I appreciate your comments. I'll certainly take them into consideration. Mr. Parks, good morning.
For the record, Bruce Parks, Chairman, Washington County Republican Party, ditto what Mark just said.
Thank you, Mr. Parks. Is there any other ma'am, I see your hand is up. Would you be able to unmute and state your name for the record, please?
My name is Elaine St. John, and I'm from Lyon County. I talked to a couple of voters, a number of voters, regarding the color for the return, ballot. And many of them, majority, let's say, were concerned that the color would make it easily identifiable for bad players. So, they say, look, it's bad enough we have mail-in ballots, but now we're concerned that perhaps my postal carrier, who knows that I'm Republican, they're just very concerned about the color. They think it should be non-identifiable. And I would agree with that. Thank you.
Yes, ma'am. Thank you, Ms. St. John. Appreciate your comments. And to be clear, the color would be county specific, certainly not like a party affiliation. But I understand. And in fact, I know that touches on a little bit of a concern that came out during the primary of the 2020 election cycle, actually, where there were concerns about indications on a ballot, suggesting that the party of the individual casting the ballot, and that those concerns would carry over to the general election. Again, because we have a closed primary system in Nevada, of course, the ballots for each major party is different. So in that regard, that is something that does not carry over to the general election, and there are no indicating features anywhere on the ballot envelope that indicate what party affiliation anybody has. This color envelope would certainly be a continuation of that, but I do appreciate your comments this morning. Thank you. At this time, are there any other individuals interested in making a public comment regarding proposed regulation R099-21P?
I believe Teresa Kolsnick has her hand waving.
Yeah,
Oh, I'm sorry. I apologize. I've got to expand my, thank you for pointing that out. Ms. Kolsnick, good morning.
hi, Teresia Kolesnik. I just have a couple questions. Now, on the bottom of the ballots, I hear there's QR codes or, those lined codes on the bottom. And I was told that doesn't matter what you vote for, if this is controlled by Eric, they can put in any code they want and make the election fraud. Is that true? And can you hear me?
Yes, ma'am.
Oh,
I was going to
okay.
wait for you to finish. So is that your?
Yeah, and also in Pennsylvania, the court determined that all mail-in voting is unconstitutional, except for military or, illness or, good reason. Now, why wouldn't that carry over to the rest of the states and to our state especially? That's all I have to say. Thank you.
Yes, ma'am. Thank you for your questions. First and foremost, a decent amount I have to unpack in that first question. Eric has no ability to influence or alter anything at all relating to our elections, period. Full stop, not even remotely close. Again, love to explain the entirety of the Eric process, but it's very much a passive comparison of information to make sure that very similar to what we do between our counties. When the counties provide information to the Secretary of State, we look at the list of Clark County against all the other counties and we compare all of them, looking for duplicates, possibilities of duplicates, individuals who have a similar first name, last name, similar date of birth, and other information that we have access to. And then it just raises questions and we identify those to make sure that we don't have duplicates on our voter registration lists. And that does happen because people move. And when folks move across the state, they typically do not update their county clerk or registrar that they've moved. They don't cancel a voter registration. So that's all kind of built into the process to make sure that we're updating our lists as people are moving. And Eric, again, has no ability to do any of that. Ballots do not have QR codes or barcodes on them. The ballot envelopes do, because every ballot that is sent out is sent to an active registered voter. And it's important that that ballot is tied to an active registered voter. We don't just send out ballots to addresses, they're tied to people who are confirmed as being eligible voters. And what does that mean? That means they've met all of the requirements from the statutes in the Constitution to be an eligible voter in Nevada. One of which, by the way, requirement is that they are an American citizen. So in that regard, we do actually confirm that they are an American citizen. It's by them attesting to the fact, again, under penalty of perjury, they're an American citizen, which I know some folks are aware of. But when it comes to the ballot, the barcode on the ballot envelope itself, the intent behind that is so that when your clerk or registrar mails you a ballot and you receive that ballot, if you decide to mail it back, you decide to return it in person, or if you decide to discard it and vote in person, all of those different methods for you to return it are tracked through an election management system. So what does that mean? If you bring your ballot to your clerk and hand it to them, once it gets inside the building, one of the first things they do is they scan that barcode on the envelope, and that identifies that you are casting a ballot. Then it goes through the rest of the process, and I suspect we'll talk more about that process later today. If you vote in person, when you go in and check in at the polls, that updates your registration info to say that you've cast the ballot in person. That matters because if you vote in person or if you vote by mail, it negates your ability to vote the other way. In fact, we know exactly how many people voted in person and then tried to vote it by mail as well. Because when we scan the ballot, the barcode that's tied to the voter pops up and says, nope, this individual already voted in person. This ballot does not count. It will not be cast. And by the way, that's a violation of NRS 293-780. So that's the intent behind the barcodes. The last portion about your question in regards to Pennsylvania's recent litigation, I'm unfortunately not too clued in as to what that discussion looked like. But again, there's a number of different ongoing lawsuits that will affect the national level in how elections are conducted. I'm certain if there is something that is applicable to Nevada, we will certainly hear about it and move forward in that regard. But again, that's not something that is within the scope of our regulation adoption hearing today. But thank you for your questions and comments this morning. Is there anybody else interested in providing public comment regarding to proposed regulation R099-21? Okay, hearing no further public comment, proposed regulation LCB file number R099-21 is adopted and will move forward to the Legislative Commission. I will now open the adoption hearing. On proposed regulation R100-21. R100-21. Existing law authorizes certain persons to demand and receive a recount of the vote at an election. A person who demands a recount must deposit in advance the estimated cost of the recount. If the person who demanded a recount does not prevail and it is found that the sum deposited was less than the cost of the recount, the person is required upon demand to pay the deficiency to the county clerk, city clerk, or secretary of state, as the case may be. If the sum deposited is in excess of the cost, the excess must be refunded to the person. If the person who demanded the recount prevails, the sum deposited with the secretary of state, county clerk, or city clerk must be refunded to the person. Existing regulations provide that 1, a person who demands a recount of votes may withdraw the demand by filing a withdrawal in writing before the completion of the recount, and 2, the county or city clerk must stop the recount as soon as practicable after such a withdrawal is filed. This regulation provides instead that 1, a person may, before the completion of the recount, file a withdrawal of demand in writing with the officer with whom the person filed the demand, and 2, each county or city clerk who was conducting the recount must stop the recount as soon as practicable. If it is found that the sum deposited for the purpose of the recount is 1, less than the cost of the recount at the time of the withdrawal, the person must pay the deficiency to the county clerk, city clerk, or secretary of state as applicable, or 2, in excess of the cost of the recount at the time of the withdrawal. The excess must be refunded to the person. There are no considered modifications to proposed regulation R100-21P following the previous workshop or received public comment. At this time, though, is there anyone else who wishes to speak on proposed regulation R100-21P? This time, please raise your hand. Yes, ma'am. Ms. Colson, please.
Yeah, now, are we still having drop boxes for ballots?
Yes, ma'am. A little bit outside of the scope of this regulation, but yes, we actually are required by law to have a certain number of drop boxes across the state.
Doesn't that set it up for fraud?
No, ma'am.
Well,
Which
I've
is-
seen a lot of videos with that going on.
Yes, ma'am. There's a number of things that we've done and incorporated to make sure that, again, to the best of our abilities, and further things that we're looking to the future as well, to prevent or further mitigate the risk of fraud.
Okay, thank you.
Yes, ma'am. Mr. Camp, please.
Thank you. For the record, Mark Camp, Republican for Nye County Clerk. I guess being an accountant in my background, sort of, and an auditor, my question would be, how do we determine cost? While you want to make sure that the county or city clerks are not, burdened in any way with costs that are in excess of they can, support. You also want to make sure that the voter or anyone who might challenge a vote is not charged more than actual cost. So I recommend that there be some sort of standard for determining cost. If that is covered somewhere in the regulations, I'm not aware of that, or if that's covered in some other way, I'm more than happy to see what you have to say on that. But thank you.
Thank you for your comments, Mr. Kemp. Yeah, a great point. And a little bit of background. You're right. First of all, it is not covered in this regulation. I will take it down as a consideration for future regulations. But a little bit of background for when it comes to recounts. If it's a statewide recount, for example, what we end up doing is we consult with the 17 clerks and registrars and ask for cost estimates based on the number of personnel they would need. There are very specific requirements in the statutes about the timelines. For example, it's through weekends. There's a deadline in the number of days that the recount has to be accomplished. So given the nature of the recount, the clerks provide us a cost estimate. Probably not too surprising that there are differences in those cost estimates based on the locations across the state and the availability of temporary workers, for example, to conduct a recount. And that's really what ends up driving the cost estimate that we receive for a recount. But I do appreciate your comments, and we'll take them into consideration going forward. Thank you.
I think that you've answered my question. I believe that as long as the clerks are involved and that it's getting a secondary review, I think would be okay.
Yes, sir. Thank you. I've got one question from Ms. Penny in the chat. Ms. Penny, would I be able to get your name for the record so I can record it? Perhaps in a minute. Oh, there we are. Thank you. Ms. Brock, her question is, Mark, how can you alone determine a reg is adopted during legislature, always done by a vote or elected legislators, whether in hearing or in a full floor session? You are not elected to make determinations. So what gives you the authority to act alone? To be clear, Ms. Brock, the adoption process, again, is as you see it. But this isn't finalized, of course, until we get to the Legislative Commission, when the elected officials will be ultimately determining, again, whether or not these go forward or not. So this is part of the statutory process that again, if you're interested, we could either discuss further later, or Mr. Greg Ott is on the line today. But I think in general, again, the regulatory process is prescribed in statute and regulation, so we are following it very closely to make sure that we stay within the confines of the law.
Yeah, and Ms. Brock, I'll just add that Mark is acting under the authority of the Secretary of State, which is specifically delegated to her by the legislature. So if he takes his Secretary of State hat off and acts as Mark, he has no authority to do anything. The only authority he has is vested to him through the Secretary, which is then handed by the legislature. So otherwise, he's correctly described the regulatory process.
Thank you, Mr. Ott. At this time, is there anybody else that is interested in providing public comment regarding proposed regulation R100-21? Okay, hearing no further public comment on R100-21 is closed, and proposed regulation LCB file number R100-21P is adopted and will move forward to the Legislative Commission. I'll now open the adoption hearing on proposed regulation R101-21P. Existing law 1 requires the county clerk to cancel the voter registration of a person upon the determination that the person has been convicted of a felony and is currently serving a term of imprisonment, 2 provides that a person convicted of a felony who has served his or her sentence and has been released from prison is immediately restored the right to vote. And 3 authorizes any such person to re-register to vote upon the release from prison. Existing regulations provide that the Secretary of State will immediately provide the county clerks with information the Secretary of State receives from the Attorney General of the United States regarding the conviction of any person of a felony. Section 2 of this regulation provides instead that the Secretary of State will immediately provide the county clerks with any information the Secretary of State receives from the Attorney General of the United States or the Department of Corrections regarding any person who is convicted of a felony and sentenced to a term of imprisonment. Section 2 also removes obsolete language related to the former process of restoring the voting rights of a person who is convicted of a felony. Existing regulations require a county clerk to count a provisional ballot under certain circumstances, including that a voter has not been convicted of a felony, or if the voter had been convicted of a felony, the civil rights of the voter had been lawfully restored. Section 1 of this regulation removes this obsolete language in order to comply with the applicable provisions of the Nevada revised statutes. There was a lot of public comment we received regarding this regulation as well. This is one that ultimately, again, there's a number of discussions that will be ongoing in the possibility of some future regulations following the 2022 election cycle, given the detail of those discussions. Of note, also there's work underway, and this also relates back to the statewide voter registration list maintenance process, where we are setting something up, and we're working right now with the Department of Corrections to more closely mirror what we have with the Office of Vital Records, so that when individuals are convicted and incarcerated, that the Secretary of State will be noticed so that we can notify the clerks in order to appropriately cancel those individuals. And then similarly on the far side, when individuals are released, to be notified as well. Again, not as a means for justification, but simply so that way, again, if questions come up regarding to those individuals' eligibility after their restored rights, again, we have documentation from the DOC already in hand and can help facilitate their re-registration. At this time, Ms. Thomas, please.
Thank you, Tracy Thomas, for the record. And I just would like to reiterate that any person who completes a written affirmation required should not be provided a provisional. Only a citizen who completes a written affirmation required should be provided with a provisional ballot. I just would like to have that very clarified in our regulations. Thank you.
Yes, Ms. Thomas, thank you for your comment. On that, along those lines, by the way, just for your awareness, that you brought up some really good points about the difference between person and citizen. You know, a cursory review of one chapter alone of our the regulations indicated there was about 190 uses of the word person. This is something that we're going to consider going forward. But the concern is that we can't just find and replace all 190 with citizen, because some of those instances relate to observation where there is no requirement, right? You don't have to be a citizen to observe our elections. And there's other situations across the regulations where person is the appropriate term. Instead of attempting to rush that process, again, that is something that we're going to consider and look at for future regulatory cycles. But thank you for your comments.
I appreciate that very much. Thank you. I do realize there are some instances where person is appropriate, but the majority of them would be applicable to citizen. Thank you very much for that effort.
And again, that ultimately was something that we would need to look, you know, across really, you know, all of our chapters in Title 24, which again, for those of you that aren't familiar, when you hear me say Title 24, and just to make sure that we're clear on that, I'm referring to chapters of the Nevada revised statutes that relate to elections. So specifically, that's 293, 293B, which deals with mechanical voting systems or devices, 293C, which deals with city elections, 293D, relating to Uniform Military and Overseas Absentee Voter Act, which is actually not what UOCAVA is, but that's what the Uniform is an Overseas Citizen Absentee Voter Act. That's 293D, 294A, which relates to campaign practices, 295, which relates to certain state and local ballot questions. 298 talks about presidential electors and elections. 304 talks about the election of U.S. senators and representatives. And then chapter 306 relates to the recall of public officers. So there are regulation chapters relating to each of those, and that sort of assessment, and really all assessments that we've done in regards to our regulations relate back to all of those chapters of NRS. Ms. Martinez, good morning, please.
Good morning, Mark. For the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. For purposes of this discussion, I want to make sure I understand correctly about the restoration of voting rights for convicted felons who have completed their sentences. If I'm understanding this correctly, it's once they've been discharged from Department of Corrections. I'd also like to know if there's any means of reconciliation on actual completion of those people's sentences. For example, based on my own experience in law enforcement, convictions often, when they levy financial sentences against convicted persons, the language in those court documents indicates that it's also a recoverable lien against that person. So it's supposed to get recorded. So what I've seen over my years of law enforcement is many people who are indigent have financial consequences levied against them. Sometimes it's worked off either through probation, community service, etc. But there still are financial consequences hanging out there on many, many convicted felons. So my question to you is, what is a reconciliation process to truly ascertain that these people have, quote, paid their debt to society, close quote? Because just being released from Department of Corrections does not necessarily mean that they've completed their court sentence. And if I'm missing any points there, if you have any information about that, that would be helpful for us to understand. Thank you.
Thank you, Ms. Martinez, for the question. Again, truthfully, I don't have the answer directly in front of me, but I have made a note about that, and I'm going to follow up, get some detailed information so I can get back to you as soon as possible. But I don't have the details on that as it relates to this regulation right now. But yes, ma'am, I will follow up.
Well, I think that that's critically important. If you're going to adopt regulations today and forward to the Legislative Commission, and you can't answer that for us today, I don't think that we can support that. Because if felons, and God bless them, if they have truly rehabilitated, if they have not truly paid their debt to society, there is an outstanding debt, and they are not entitled to full restoration of their voting rights.
Yes, ma'am. I understand exactly what you're saying, and I simply don't want to misspeak or attempt to interpret a provision of the multiple chapters of statutes that I simply don't have memorized in front of me. But I will, like I said, get you an answer as soon as possible. Ms. Guerrero, good morning.
Good morning, Mark. For the record, my name is Matilda Guerrero. I'm the Democracy Manager at Silver State Voices, and I'm here on behalf of the Let Nevadans Vote Coalition. I'm proud to say that here in Nevada, formerly incarcerated Nevadans are members of a quickly emerging voting bloc with the passage of Assembly Bill 431 from the 2019 legislative session. All formerly incarcerated citizens, no matter the status of their probation or parole status, have their right to vote restored. As Speaker Frierson said, who sponsored 431, the point of this bill is clear. When men and women have completed their sentence and rejoined society, they should be able to fully embrace civic engagement, and that includes restoring the right to vote. Thank you.
Thank you for your comments, Ms. Guerrero. Ms. Dermott, good morning.
Good morning, Mark. My name is Carrie Dermick with All Voting is Local. My comments are I just want to say thank you for communicating with the Department of Corrections moving forward so that we can make sure that previously incarcerated voters know about their new rights based off the law in 2019 431. Thank you so much. Have a good day.
Thank you, you too. Mr. Parks, please.
Thank you, Mark. Again, Bruce Parks, Chairman, Washoe County Republican Party. I would just like to state again for the record that I am adamantly opposed to full restoration of all your rights simply upon release from incarceration. There should be an application process similar to what you must go through to restore your Second Amendment rights, which are restricted if you are a convicted felon. There is an application process for you to have those rights restored. They are not automatically granted to you upon your release from incarceration. The same standards should be applied to voting rights. Thank you.
Thank you, sir. At this time, is there anybody else interested in providing public comment regarding proposed regulation R101-21. Okay, at this time, hearing no further public comment is closed on proposed regulation R101-21. Proposed regulation LCB file number R101-21 is adopted and will move forward to the Legislative Commission. I will now open public comment. I will now open the adoption hearing on proposed regulation R102-21. Existing law authorizes a registered voter to challenge the right to vote of another person if one, he or she is registered to vote in the same precinct as the person whose right to vote is challenged, and two, the challenge is based on the personal knowledge of the registered voter who submits the challenge. The challenge must, one, be signed and verified by the registered voter who submits the challenge, two, name the person whose right to vote is challenged, and three, name the ground or grounds as applicable of the challenge. Existing regulations require any such written challenge to be on a form prescribed by the Secretary of State and contain certain information, including one, a statement of the facts upon which each ground for the challenge is based, and two, a statement that the challenge is based on personal knowledge of the facts upon which each ground for the challenge is based. This regulation requires that a written challenge also contain any documentation or evidence supporting the facts upon which each ground for the challenge is based. Existing law provides that if a written challenge to the right to vote of another person is filed and the challenged person applies to vote, an election board officer is required to tender the challenged person an oath or affirmation. The oath or affirmation is required to be in a certain form depending on the reasons set forth in the challenge. If the challenged person executes the appropriate oath or affirmation, he or she is allowed to vote. If the challenged person does not execute the appropriate oath or affirmation, with certain exceptions, the challenged person must not be issued a ballot. Existing regulations require that the oath or affirmation of the challenged person must be on a form prescribed by the Secretary of State and contains certain information, including one, a statement of the facts upon which each ground for the challenge is based, and two, a statement that the challenge is based on personal knowledge of the facts upon which each ground for the challenge is based. This regulation requires that the oath or affirmation also contain any documentation or evidence supporting the facts upon which each ground for the challenge is based. And in this regulation, there was some, again, additional public comment that we received relating to the timing of this date. And I do want to clarify for the record and for all of you so that we're on the same page in that regard, that ultimately in our discussions, our hands were a bit tied. We identified the issue and discussed in our discussions with the Legislative Counsel Bureau, LCB, but in this case, they restricted us to this interpretation. Again, signifying, right, that we are not able to just make decisions as we please and propose regulations. We are, of course, confined by the law appropriately. This proposed amendment would have clarified that time period referenced in NRS 293-547 refers to a specific window of time in relation to the day of the election. So more specifically, we have amended this document now so that it does include the text be filed with the county clerk after the 30th day, but not later than the 25th day before the day of the election. So 25 to 30 days before election day itself for a primary, general, or special election. So that is the additional text that you will see in the amended version when it is completed. At this time, if you're interested in providing public comment regarding proposed regulation R102-21, please go ahead and indicate in the Zoom now. Ms. White, please.
Thank you. The oath or affirmation of the challenged person, is that required to be an in-person oath or affirmation? How do they submit that? If you get what I'm asking? Yes,
ma'am. I believe I do. Again, I think that with maybe rare exceptions, it will be in-person affirmation. I can't think of a situation maybe why somebody would do it otherwise, but the intent, as I understand it, is to be in person. Okay, well, shouldn't it be spelled out that it should be in person? Because the last thing we want is to have ballots going to, say, phantom voters, and then phantom voters being mailed an oath or affirmation, and then they send that in. There's really no security in that process. It needs to be in person. I understand your concern. I guess I was thinking it's either going to be in person or maybe virtually so that you can see the individual. But yes, ma'am, I will take that into consideration. One moment, please.
Yeah, it just says if the challenged person executes the appropriate oath or affirmation. It doesn't say anything about, you know, there's a real person attached to this name. Even a Zoom is a little bit untrustworthy. Definitely not a phone call. And I don't know, I mean, does it need to go into detail about what the oath or affirmation includes? I do reside at this empty lot. I mean, whatever the challenges were to that person, they should be able to counter it as false.
Yes, ma'am, I understand your concerns. One moment, let me review something real fast. Yes, ma'am. Looking over, and this is in NRS 293-303, subsection 8, section 8, subsection B. It does include some additional details regarding the individual has to show official identification, photograph, driver's license, and execute the oath of affirmation. So that implies that it's not something that's possible over the phone. And I think that's part of the implication there. I see what you're saying though, in regards to you know, in clarifying by regulation the need for it to be in person. I'll have to at this time take that back and conduct some further research and discussion. But I do appreciate your feedback. Excellent points. Thank you.
Yeah, I'd just like to, as you started out this morning saying that you had extra funding for the 2020 election, which enabled you to have staffing, et cetera, that you needed. Okay, so what I don't want to hear is that in future elections, that because you didn't have the funding for all the extra staffing and man hours, that you had to expedite the process and allow phone confirmations and allow digital or paper confirmations. So I really do think it needs to have in person someplace in there by an election authority. Thank you.
Yes, ma'am. Thank you. I understand. And certainly, again, no corners will be cut. The integrity of the election process is extremely important. Not only the Secretary of State, the staff here in the Elections Division, but all of the county clerks and registrars. But I do appreciate your comments and feedback. Mr. Kampf, good morning.
Yes, Mark Kampf, for the record, Republican candidate for Nye County Clerk. My concern about this is that much of the documentation is based on what the DMV requires to get a license, and that those requirements to actually prove residence only involve an affidavit. That's the same thing that is required by this. I recommend that this regulation spell out what actions the clerk or city clerk or secretary of state needs to take to validate or verify the information that is provided, other than just an affidavit, because anyone can sign a affidavit and raise their hand and say, I live at this location and I'm authorized to vote here. And it's just as bad as the affidavit that's signed at the DMV. So without any follow-up action by the Secretary of State, then there's no way to determine what the process is to verify each individual's claims. And I recommend that that be added to this in some way, shape, or form. Thank you.
Thank you, Mr. Kemp. Do you happen to have any suggestions on how to validate 1.8 million addresses outside of the use of official election mail, by any chance?
Well, we're only referring to a challenge.
Okay. Oh, I see. Right. Of course. I see.
We're just referring to a challenge. And in case there's a challenge, this is not identifying the steps need to be taken. For example, one of the things that could be done is that the clerk could ask the district attorney in that county to investigate, and they have investigators who can validate the information that's provided in the forms that are required. That puts it back into legal grounds. It could also be put on the shoulders of the sheriff or the the law enforcement agency within that county. And I'm not talking about the 1.8 million. I'm just talking about legal challenges. And I know these are not that common, but we could face that considerably in the next election because people are concerned about non-citizens, non-residents voting in our state.
Thank you, Mr. Kemp. I understand. I appreciate the clarity. I do want to pause 1 second just to remind everybody. Again, while this is a virtual setting, I do ask that you again remember some elements of decorum, and again extend to each other dignity and respect. This is being recorded for the record. This will go on to our YouTube channel. We will post on our webpage. It's very possible that there will be school children that watch this one day to understand the regulatory process so that they can participate appropriately. So looking over the chat, again, gentle reminder, but please, if you would, be mindful of your language. And again, please extend dignity and respect to each other as you would want to have done if we were in person. Thank you. And again, thank you, Mr. Kemp. Ms. Thomas, please.
Thank you. I just wanted to, so was there any changes made on this regulation changing persons to citizens in your amended copy?
No, ma'am. So that your suggestion is something that we were going to view holistically across all of our chapters that relate back to Title 24. So all of those chapters of NRS that I referenced before have associated chapters of NAC relating to them. And it wouldn't, I felt it'd been right to just pick one chapter and to go try to address, person to person or person to citizens in one unique case, but instead are going to view that holistically to look into the feasibility of that going forward.
So just since we're going ahead and amending this one at this time, is it not prudent to go ahead and at least correct this one at this time to so for instance, under section 1C, the name and address, telephone person of the citizen filing the challenge in, and D, the person or the citizen filing the challenge is a registered voter, because we know that there are non-citizens registered to vote at this time on the rolls. Thank you.
Thank you. Mr. Parks, please.
Thank you, Mark. My question is, there's no specific timeline referenced in this proposed change that indicates when these challenges have to be submitted or when it is no longer an option to challenge a suspected person not eligible to vote or whatever. Is there a plan to incorporate language of specific timelines? Thank you.
Yes, sir. So the amended text that you will see when it after we're done with the adoption hearing, it will specifically call out and say the exact phrase is we've added quote, be filed with the county clerk after the 30th day, but not later than the 25th day before the election. So that text, again, will be coming up shortly. For your awareness, and just to save you the time of calculating, that window of time is May 15th to May 20th for the primary election, May 15th of 2022 to May 20th of 2022 for the primary election. And October 9 to October 14 for the general election. There are other timelines associated with different types of challenges laid out in the statutes. But again, this is just specific to NRS 293-547. Those are the adjusted timelines, and those will be in the text. Yes, sir.
So you're basically talking, you have a 5-day window of opportunity to correct possible errors on the voter rolls before the primary and just before the general.
As it relates to 293-547, yes, sir. There are different timelines associated with other types of challenges, though.
Understood.
But yes, sir. And that's again in the statutes. But yes, sir.
Thank you.
Ms. Dermick, please.
Hi there again. My name is Carrie Dermick. I'm with Albany's Local. I just wanted to go back, I think, to some of the first comments and just mention that sorry about this. Wouldn't a notarized affirmation be sufficient in that case? And just wanted to throw that out there. Thanks so much.
Thank you, Mr. Dermick. We'll take that into consideration as well in possible incorporation into future regulations. In regards to the notarized affirmation.
Yeah, just all the back and forth before.
Oh, right. I understand.
I want to throw that comment, that suggestion out there if that would help move it forward. Yeah. Mhm.
Yes, ma'am. Thank you. Ms. White, yes, please.
I do. So there's a timeline of 5 days, basically, when the challenged voters can be submitted. But it seems like it's open over the entire voting season for the challenged individual to say, hey, wait, I do get to vote. I still see it's problematic that these people are going to show up on election day or whenever in the thousands and say, I get to vote. Why am I challenged? Okay, so then it's on the Secretary of State's office to say, well, how are we going to make sure or confirm that all these people are legit? And it's going to be a jammed rush through without looking at the actual details again. And I'm opposed 100% against notarized affirmations. Are you kidding me? All you need are anybody can become a notary public, and you can get plenty of crooked notary republics. That's absolutely horrible. Thank you.
Yes, ma'am. Thank you for your comments. And to clarify, so you're right. If I challenged an individual who was registered at my address that maybe had moved, you're right. Ultimately, if they moved and then confirmed their registration with their clerks, then they would be able to vote. That is not a process that is ever has been or ever will be expedited or rushed. You'll find that all 17 clerks, registrars, and their staffs are very good at that process, are very clear in their understanding of the requirements. And if somebody does not meet the eligibility to cast a legal ballot, then they don't. It's just that simple. But I understand your comments and I appreciate them. At this time, is there anybody else able to provide or interested in providing public comment relating to proposed regulation R012-21?
Yes, I mean, when Carrie Dermick mentioned that a notarized affirmation would be good, you said, yeah, we'll put that in the regulations.
No, ma'am, I didn't. I said I'd consider it. To clarify, then I will take her comments into consideration, as I will everyone's.
Okay.
But
It'll be interesting to see if it actually shows up, because I gave you an argument against it as well. Thank you.
Absolutely. And again, I appreciate your comments and we'll take them into consideration as well. At this time, is there any other comments on proposed regulation R012-21? Hearing no further public comment is closed. Regulation LCB file number R012-21 is adopted with the changes as mentioned on the record just a moment ago, specifically citing the exact time period that the challenge may be filed pursuant to NRS 293-547. At this time, I will open the adoption hearing on proposed regulation R103-21P. Existing law 1 requires the county and city clerks to prepare and distribute to certain registered voters a mail ballot for every election. 2 requires the county and city clerks to check the signatures on receiving mail ballots. 3 authorizes each mail ballot central counting board to begin counting the received mail ballots 15 days before the day of the election. And 4 requires each mail ballot central counting board to complete the count of all mail ballots on or before the 7th day following the election. Sections 1 and 3 of this regulation require each county and city clerk as applicable to report to the Secretary of State during certain periods. 1, each registered voter that has been sent a mail ballot. 2, each registered voter whose mail ballot has been received by the clerk. 3, whether the clerk has completed the process for checking the signature of a mail ballot. And 4, whether each mail ballot has been processed and counted by the mail ballot central counting board. Existing regulations require each county clerk to electronically transfer certain information to the statewide voter registration list at least once each business day. When a county clerk electronically transfers such information to the statewide voter registration list, the county clerk must certify that the county clerk has complied with such applicable technical requirements for security as may be prescribed by the Secretary of State to ensure the confidentiality of the information transferred. Section 2 of this regulation requires instead that when a county clerk electronically transfers such information to the statewide voter registration list, the county clerk must certify that the county clerk has complied with such applicable technical requirements for security as may be prescribed by the Secretary of State to ensure confidentiality of the personally identifiable information transferred. Now, there were some additional, again, this is another one that we received significant public comment on, and I'm going to describe now the amended changes to the text that you see before you. Okay, so we realized that in proposed regulation R013-21P, the term counted as used in section 1, subsection 2, specifically, well, in that one sentence, the very last word, the word counted is actually the wrong term. That would create confusion and voter frustration. You see, after a mail ballot is received, it is immediately put through the signature verification process. From there, it is sorted by precinct and then moves on to have the ballot separated from the envelope. In many counties, the closer to election day and up to 4 days after, they don't actually receive enough ballots to process and count. So they receive them, verify the signature immediately, sort them by precinct, and then lock them up in a vault until they have enough to assemble the ballot processing team. Sometimes this is a day or two later. So there could be a couple days between the day the ballot is received and the day it is actually counted. Also, and this happens every election, there will be ballot envelopes that get received, processed, and the signature confirmed, only to find out that the envelope is empty because the voter forgot to put the ballot in the envelope. Therefore, instead of creating an impossible requirement, section 1, subsection 2 of the proposed regulation will be amended to state, in addition to the information required pursuant to subsection 1, beginning the 15th day before an election and through the 7th day following an election, following the election, each county clerk shall, at least once each business day, inform the Secretary of State of whether the mail ballot of a registered voter has been processed and the signature accepted. That's the change from counted to signature accepted. So that way the clerks can clarify that a ballot has been processed, but are not stating that it has been counted, which in fact comes later. At this time, if there's anybody interested in making public comment regarding proposed regulation R103-21, please go ahead and indicate so now in Zoom. Mr. Parks, please. And then this will also give you an opportunity to remind everyone that the chat is intended for asking, indicating that you're interested in asking a question and perhaps not bantering back and forth, if you would please. There's plenty of social media sites that make that acceptable, but please not today. Mr. Parks, do you have a comment regarding proposed regulation, R103-21?
Yes, sir. I just wanted to ask about the stand by 1 second.
Yes, sir.
Mark, can you come back to me later, please? Thank you.
Yes, sir, absolutely. Is anybody else interested in making a comment regarding proposed regulation R103-21? Mr. Cliff, sir, please, if you don't mind, state your name for the record and ask your question.
Yeah, my name is Cliff Nellis. You know, this proposal says you have 7 days after the election to count the ballots. Is that right?
So the statutes say that, again, now this is pursuant to Assembly Bill 321, that the county clerks have up to 4 days after the election to receive a mail ballot, as long as it was postmarked by election day, and then 2 additional days to conduct signature verification. So it's 6 days after the election that it's possible to count a ballot. Yes, sir.
I think that's a good reason not to have any mailed ballots, because I mean, that means we don't have an election day, do we? We just have an election week, I guess it's called. And during an election week, you can do a lot of vote fraud or election fraud if you're up to that. You know, if you have the technology all set in place. I mean, I see this as opening up our voting process to all kinds of fraud. And just for your information, Mark, I was down there watching in Washoe County the vote signature verification right there in the office there at the registrar. And you know what I could see? I could see the back of a computer screen. That's all I could see. And Deanna Spicula got really mad at me when I said to her, hey, can I see what they're actually verifying, if these signatures actually even look like each other? I could not observe. I was not permitted to observe. And she got mad when I said I wanted to observe. And then I said, well, how about you guys stick a little camera behind these 6 tables? Because there were 6, and with their screens facing the other wall. So maybe we could look at it later, you know. Oh no, she wasn't open to that suggestion either. So, you know, this whole thing about signature verification, I don't think it actually goes on. And I think it all depends on who's running the signature verification and what their political persuasion is. And I'm not sure of Mrs. Spicula's political party, but I would assume it's probably Democrat. I don't think it's a good idea to have 7 whole days. I mean, if you're going to do mail-in voting, that's fine, and make it the cutoff day on 4 days before the election day, or 6 days if you need 6 days. That's what I think. You know, if you want to do that, that's fine. But even the mail-in voting, I mean, that's an open door for all kinds of fraud. You know, Dinesh D'Souza is going to put out a thing about 2,000 mules running around stuffing ballot boxes, you know, drop-off boxes. And so I can't wait to see his little documentary there and how they do that. I wonder if that was done here.
Yes, sir. And just to clarify, again, these regulations cannot supersede, alter, or replace the existing statutes. Those timelines are not something that's in the scope of this regulation. So there's a separate process to change those laws if that's something that you're interested in doing. But I do appreciate your comments and have made notes of them.
Okay, thank you,
sir. Ms. White, did you have a comment?
No, thank you.
Mr. Parks, did you have a comment before I move on? I wanted to give you an opportunity one last time.
No, thank you. I appreciate it, Mark.
Yes, sir. At this time, if there's nobody else interested in making public comment. Let me check. Okay, hearing no further public comment, I'll close public comment on proposed regulation LCB file number 103-21. It is adopted with the changes as mentioned on the record. This time I will open public comment on, this time I'll open the adoption hearing on proposed regulation R104-21P. Existing law requires the Secretary of State to 1, establish and maintain the statewide voter registration list, and 2, enter into a cooperative agreement with the State Registrar of Vital Statistics concerning the death of residents of the state to maintain the statewide voter registration list. Existing regulations provide that on each business day, the Secretary of State will compare the statewide voter registration list to the vital statistics records maintained by the State Registrar of Vital Statistics. If the Secretary of State determines that a registered voter is indicated as deceased in the vital statistics records, 1, the Secretary of State will notify the county clerk, and 2, the county clerk determines that the voter is deceased. The county clerk must cancel the registration of the voter in the county's computerized database of voters and the statewide voter registration list. This regulation provides the Secretary of State will determine on or before February 1st of each year whether each county clerk has indicated in the county's computerized database of voters and the statewide voter registration list that the registrations of the voters in the county that are indicated as deceased in the vital statistic records have been canceled. This one, again, we also received significant public comment regarding, again, via email form. And I would like to address that now. So there's a few things to address specifically regarding our feedback. First, the removal of dead voters does in fact occur every day. The Secretary of State receives information from the State Registrar of Vital Statistics, and that information is provided to the clerks who confirm and then remove the deceased voters. That confirm is an important part. Far more individuals share a first name, last name, or even in some rare cases, birth dates from individuals who are deceased. So we confirm it using all available information that is pretty lengthy to ensure that the right person is canceled. This proposed regulation is intended to reconcile that daily process to ensure that the appropriate actions have been conducted prior to an election. Going forward, and upon completion of the transition to a top-down voter registration system, this reconciliation will be conducted far more frequently. Of note, the removal of deceased voters is not prevented under the federally mandated 90-day blackout period and can continue up to the day of the election. Therefore, we will, again, amend the language of this proposed regulation from on or before February 1st of each year to on a monthly basis. So again, specifically in proposed regulation, LCB file number R104-21, if you look down in section 1, subsection 3, the first 7 words are on or before February 1st of each year. We are changing that instead to on a monthly basis. At this time, is there anybody interested in providing public comment regarding proposed regulation R104-21? If so, please go ahead and indicate so in Zoom now. Ms. Thomas, please.
Thank you. I did find I posted in the chat the link to the the state's vital statistics website, and on there they have that the list is coming soon. Do you have any idea when that list might be coming?
Sorry, I'm not familiar with the list that you're talking about.
The list of vital statistics, birth and death vital records. And they have a link to a list, but then you click on that list and it just says the listserv is coming soon.
Oh, I see. I'm not familiar with their processes or what the Office of Vital Records is working on. No, ma'am. So I know we get information from them on a daily basis, but I don't know if maybe they're working on some sort of portal for the public. I'm not certain about that.
So is that information public record?
I suspect so. I can't speak to what the Office of Vital Records is working on or what they're referring to there, though.
Okay, thank you.
Yes, ma'am. Ms. Martinez, please.
Yes, thank you, Mark. Again, Cindy Martinez for the record, Vice Chair of the Washoe County Republican Party. If I'm to understand this regulation and the proposed changes, in theory, if what is supposed to be accomplished as you described, where dead voters are being removed every day, can you explain to us then how it is when former Assemblywoman Sharon Angle conducted her election integrity investigation and presented evidence of dead voters on the rolls? The Nevada GOP, in presenting their information to the Carson City District Court in December of 2020, as well as presenting that information to the Secretary of State early last year, as well as the efforts of one of our own citizens, Mr. Robert Beatles, who's conducted an investigation and has still found dead voters specifically in the Washoe County voter rolls. If what you say is true and that is being accomplished, explain how, in those examples I just presented, how it is that those dead voters are still showing up on the rolls, and in some cases have had votes cast in their name. Respectfully, I don't trust this process. I don't believe that the Secretary of State's office has the tools or the ability to reconcile these public records. And having served in state government, I know that the incompatibility amongst different systems across different agencies, they simply don't talk to each other. So there needs to be a more stringent manner in which this is reviewed, accomplished, and purged. That's the only protection for that. Thank you.
Yes, ma'am. Thank you. Again, I just would like to clarify that since October of 2020, we've, again, under the direction of the Secretary and frankly, as part of our investigation into the documents that you referenced, every process, et cetera, was re-examined. We spent considerable time working with our counterparts over the Office of Vital Records. And again, won't bore you with the details of state government, but they had significant turnover because of COVID. Again, I was new to the position as well. So we did reinvigorate that relationship, because I think you're right. The collaboration, it has to increase. And since then, we've talked far more frequently. We've re-examined what was sent. We've learned significant amounts. Frankly, I found out far more about the death certificate process than I ever would have imagined even existed. For example, they're very careful in when they release an official death certificate, even when, for example, the deceased individual is not homeless, was not overseas, not by themselves, or even when they're surrounded by family and friends. It's hard to find the information needed for the Registrar of Vital Records to finalize that death certificate. And even then, there's times when it gets amended multiple times, where the Social Security number they thought they had, for example, may end up being questionable, so they hold off. So there are reasons why we don't get the information from them on a certain individual, in some cases for numerous months after. I assumed it was within 5 to 7 days at the most. So these are all processes that, again, that we've re-examined. The comparison of those vital records to the statewide voter registration list, the technical aspects of how that is conducted to make sure that we're finding individuals. There's a whole list of different ways that we're looking closely at and have already improved this process. So while individuals identified things in 2020, I can reassure you that there are significantly less deceased individuals on our statewide voter registration list now. Is it perfect? No. In the time we've had this adoption hearing, somebody has died, unfortunately, on our statewide voter registration list. I can almost guarantee that, given that it's about I think 30 or 40 people a day, I believe, that pass away that ultimately need to be removed at some point. But it's something that, again, we continue to identify ways to improve upon. But I do appreciate your comments. And lastly, we are continuing to investigate a number of other suspicious anomalies from the 2020 election cycle. But thank you. Ms. Crump, please.
Hello. My question is, and I apologize if I'm not understanding. Thank you for trying to propose this down to cleaning out the dead people monthly. That goes to the voter registrar's office for each county, and it's their responsibility to clean the voter registrars for that county. Is that correct? I'm understanding that right? If they refuse to do that and we find that they have not, what is the penalty for having not cleaned your voter rolls when you've been, through the regulations of our legislature, told to do so?
Ma'am, I can assure you, in regards to specifically what's the penalty, there's a number of different tools that the Secretary of State could use to enforce compliance. When it comes to removing deceased individuals from the statewide voter registration list, really any maintenance to that list, I will tell you that's something that the clerks personally, their staffs personally, and here at the Office of Secretary of State, the entire elections division take very seriously. We all want to do this. Nobody wants to have deceased individuals on their rolls. The reasons that again, an individual might not be, usually, or maybe the list maintenance hasn't occurred. Again, there's probably a number, but really the intent behind a monthly reconciliation, I anticipate on a monthly basis, I frankly doubt that we will identify anybody that is not in compliance going forward. What I intend to do with this modified regulation is on a monthly basis, we're going to look at the names that we provided to all 17 county clerks and registrars, and then we're going to check the statewide voter registration list to make sure that they've been removed. There sometimes is a day or two lag between us notifying the county and them, again, removing the individuals from the county lists. Maybe in a rare case, it's a week, but certainly not on a monthly basis. So again, the intent here is to simply reconcile what the clerks are doing. And there's further ongoing discussion about, again, providing some sort of location on the Secretary of State's website that we're considering, to again, make it easily recognizable and a place for the public to be able to see and confirm that the process is being done as well. So again, this is all part of an ongoing process to continue to improve, again, the security and the transparency, as I mentioned earlier.
Transparency is much appreciated. I think it would squelch a lot of questions. Thank you so much for your time.
Yes, ma'am. Mr. Sackerson, good morning.
Good morning, Ralph Sackerson from Elko, and I'll keep this brief. I just want to thank you for rolling this over to a monthly accounting, and appreciate the opportunity. Thanks.
Yes, sir. Thank you. Ms. St. John, please.
Hi, Elaine St. John from Lyon County. I am also on the Dayton Citizens Advisory Board. And I would very much like to thank you for the 30 days because that's what I was going to talk about. Thank you. I really, really appreciate it. And so do our voters.
Yes, ma'am. Ms. White, please.
Thank you. I had an aunt die and I submitted that information to the Registrar of Voters. This is in another state, but there was no way for me to confirm that she was actually removed. It was just somebody saying on the phone, oh yeah, we'll take care of that. Is there any way to confirm in Nevada that someone, a relative or whatever, has been removed?
Yes, ma'am. Absolutely. May I get her name?
Oh, no. This, my aunt was in California. I'm asking if a relative here in Nevada reports a relative's death, how can they confirm that that name has been removed from the rolls?
Oh, I see. I understand. Yes, ma'am. So there's a couple ways. Again, calling the registrar or clerk of your county is one way. Calling here in the Secretary of State, you can call us and we'll check immediately and be able to confirm. And there's also, I'm sorry?
There's no way to do it digitally, I mean, to see the actual roll?
Yes, ma'am. And in fact, let me pull up the website and I will be able to put that into the chat as well.
Thank you. And then it's the monthly requirement that they fix the voter registration for each county, but what is the requirement for vital statistics in providing the report? Do those two dates align?
So yes, ma'am. So there's, again, I think there's a number of different ways that a number of different injects that we have to support the maintenance of our statewide voter registration list. Some of these documents we receive on a daily basis. We talked about vital records. That's a daily basis type process. Others we receive monthly, in some cases quarterly, depending on the origin of the information. When it comes to the Office of Vital Records, that's actually now a daily information. There's also a yearly recap. This is something interesting that I just found out in the last couple of weeks as well, that the Office of Vital Records does an annual closeout to make sure that all of the calendar year records are completed and confirmed for the previous year. I assumed that took, again, a week or two. It turns out that more routinely, that annual closeout is completed by June or July because of the number of records they have and the importance that they take in making sure that the information is accurate. But yes, ma'am, there's again, a number of different injects, and the goal is to not only look closely at what information we get, but also, critically examining if we have the resources to increase the amount of times that we get certain information and documents to keep our rolls as clean as possible. Does that answer your question?
Yeah, and then the last thing was, you were mentioning the difficulty of sometimes confirming deaths. All you need is a dead body. That's the evidence, and the death certificate would not have been prepared and given to somebody if they weren't sure of the death. So I don't know where I missed there in your explanation.
Yes, ma'am. So again, in order to make sure that the deceased individual matches the vital statistics death certificate, there's an entire process that I'm probably not really qualified to go into detail on outside of the very cursory understanding that I have of it. I can certainly provide some points of contact with Vital Records to explain that. But again, I assumed, just like you did, that it was within like a day or two, but it turns out it's in many cases it is, but in a lot of cases it's also multiple weeks, or in some cases months.
Okay, thank you for that.
And then I put into the chat the voter search. Again, if you have the information for a loved one that you're curious about, if you go on there and search, you'll be able to identify if they're still part of the statewide voter registration list.
Thank you. And then challenging a death on a dead person on the voter rolls is no different from any other challenge.
Again, if it's like a family member that you have the death certificate and some of that information for, it's as easy as contacting the clerk and presenting that information to them. Again, they want to confirm it, of course, but that's something that there is. I know different counties have forms that you can fill out on their websites to kind of clarifies the questions and the information needed. And certainly I try to help facilitate that. You said you're in Washoe, is that right?
Yeah, but the question really is, well, just if somebody, there's lots of canvassing efforts that are happening, and they're coming up with dead people being reported, when they check, an address, oh no, this person died. And yet it wasn't cleared from the registration roll. So it should be challenged because it's not being taken care of. And I'm just wondering, is challenging the death of the dead person on the rolls any different from challenging any other person?
In that regard, ma'am, I think ultimately no. Like if you submitted a written challenge about someone's ineligibility to vote because they were dead, I don't think that would be
okay.
Yes, ma'am. I think it's acceptable. Again, that ties back into, right, like if somebody is deceased and you get official elections mail, again, the right answer is to send it back to the clerk. That'll start the timeline to get them inactivated, and then after they've been inactive for 2 federal general elections, that's when they would get canceled. But yes,
okay. And just last thing, and then I'll stop. Can you please give us the link for the vital statistics regulation that demands that they report to the regular monthly report? Where is that in the regulations, the NRS regulation?
Oh, so we actually, again, that's codified in a contract, actually between the Office of the Secretary of State and the Office of Vital Records. But yes, ma'am, our public information officer has that document available, and we can provide that as well.
Okay, thank you.
Yes, ma'am. Just a reminder again, in the chat, please be respectful. Mr. Parks, please. Not in the chat, Ms. Sparks. You're good in there in that regard. You're next.
Thank you, Mark. Again, for the record, Bruce Parks, Washington County Republican Party Chairman. I think it's great that you reconcile this on a monthly basis. However, there is, unlike vital statistics, there is no database for illegal non-citizens that are registered to vote. There is no database for, I no longer live in Nevada, but I'm still registered to vote. There is also at the county level no database for, I no longer live in Washoe County. I have moved to Nye County, but I'm still on the voter rolls for Washoe County. There's no databases for those, and it's problematic that the Secretary of State really has no way to track those pieces of information, and it'll be up to the private citizens to make the corrections in that regard. Thank you.
Thank you, sir. At this time, Ms. Guerrero, please.
For the record, my name is Matilda Guerrero. It's great to see that the legislature passed legislation to ensure that our voter rolls are accurate and up to date. This is evident in the passage of AB 321, AB 422, and AB 432, all of which stemming from the 2021 legislative session. With the passage of these bills, it accomplishes exactly what all Nevadans want, to make sure that our voter roll is well maintained. And to add on to Mr. Voloshin's comment that within the span of this conversation, unfortunately, some folks have died. That is unfortunately very true. My fiance is a first responder, and as an EMT, he often responds to DOAs. For example, yesterday he handled with 2. And unfortunately, it takes time to make sure that we have the proper documents in place. But it's important that we as everyday Nevadans do our due diligence to make sure that our voter rolls are well maintained by responding and returning election mail and even notifying our clerks. Thank you.
Thank you, Ms. Guerrero. At this time, is there anybody else that is interested in providing public comment regarding proposed regulation R104-21?
Yes.
Yes, ma'am. Would you please state your name for the record?
My name is Susan Van Ness. I'm in Washoe County. Recently, we met with Heather Carmen and Deanna Spicula, and we were addressing this situation of dead voters on the roll. I had many dead voters that I can confirm are on the rolls, but I took one. The man died in 2015. The screen was turned around so I could follow his trail. He hadn't voted since 2014. And it went down. He was still on the voter rolls until April of 2021. And suddenly there was a entry that showed he was inactive. Now, even before this, before you're going to say they're going to update these monthly, think about this. He died in 2015. He should have been long gone off those voter rolls. So if Vital Statistics is sending this daily, what is going on? Now, I have a long list of them, and I'm sure if I'd have sat with them long enough, every one of them would have still been on there. And suddenly, in 2021, put on as inactive. So we need somehow, as citizens, to be able to look on there. But when we ask for the voter rolls, we are going to be charged 1 cent per voter. Well, for Washoe County, that would cost us $2,000. So somehow we have to have oversight in making sure that the voter registrar in Washoe County is doing their job when the daily reports come in. Thank you.
Thank you, ma'am. You said your name again was Susan Van Dance. Is that correct? I just want to make sure I copied it down properly.
Susan Van Ness.
Yes, ma'am. So, I honestly, your comments indicates exactly what I was talking about. When we reached out to the Office of Vital Records, that conversation began in October of 2020 and continued, and we began receiving part of our discussion with them was these concerns that there were individuals who were deceased on the voter rolls. We identified in the discussions that the Office of Vital Records had 13 years worth of digital records. And so the very first action we did was to say, well, we would like all 13 years worth of digital records. In fact, please send them to us so that we can reconfirm that all of those individuals have been removed from the statewide voter registration list. Do you know what month we did that in? We received the first document in April of 2021. So you're right. I think at the end of the day, in years past, there were concerns, but that's part of the reason why Secretary Sagaski directed this holistic review to identify room for improvement and to make that improvement. And then to not just have it resting on personalities, but to codify it in a contract so that we are all very clear on the transmission timelines and what's going to be done and who's doing what. And then ultimately in this regulation to confirm that this important work of cleaning the rolls is done and maintained. So I do appreciate your comments. Thank you for highlighting and providing more.
May I say one more thing, however?
Yes, please.
I was told at this meeting that a postcard would go out and 2 federal election cycles had to elapse before they would take those people off. What do you think about that? A postcard goes out, and if it's not returned and they don't get it, is that 4 years?
So that is as fast as federal and state law allow. Yes, ma'am. So that you can be inactivated. I'm sorry, to be clear though, if you're deceased, you can be canceled. If you're inactivated, in the process occurs, it starts, as I mentioned, with the postcard and the returning of official elections mail. The fastest that individual can be canceled is by failing to take part in 2 federal general elections. So there's no possibility of that occurring any faster. And that is a timeline that the clerks
even though they have the death certificate and shows that they are, why are they inactivated? Why aren't they purged?
So again, for deceased individuals, they can be canceled. For everybody else that is inactivated, if somebody moves, then a piece of official election mail comes back. That's when they get inactivated, and that's when it requires the 2 federal general election cycles to occur before they can be canceled. So deceased individuals can come off, right? Again, like I mentioned before, that 90-day blackout period prior to an election, it does not apply to deceased individuals in the list maintenance process.
So you're saying deceased individuals become inactivated and then you wait the 4 or the 2 federal election cycles, or are you saying no, the deceased individuals are purged?
If we get information that indicates clearly and is confirmed that they are deceased from the Office of Vital Records, then they are canceled, period.
Okay, that's my question. These that I was showing are on your records as inactivated. That means they can always be pulled back in.
I'll clarify.
They need to be purged.
If it's possible to get the names from you, I will certainly run those to ground and I will investigate that to make sure that the appropriate label has been affixed to their voter registrations. Is it possible?
Last week on the screen in Washoe.
Is it possible for you to email that?
Last week on the screen in Washoe County, it showed inactivated. That person is deceased, should be purged, never to be used again. Thank you, I will do that.
Yes, ma'am, thank you. Mr. Parks, please.
I just wanted to clarify, there are several ways that the Bureau of Vital Statistics, a death certificate can be held up for a number of reasons. The person may, in fact, in the example that was just given, be on the voter rolls as an inactive voter for quite some time. However, as you have stated, all it requires is that person cast a ballot and they are back on the active voter rolls, even though they might be deceased. So I'm sure that you understand the issue here, Mark. If the Bureau of Vital Statistics is not doing their job, so to speak, if the maintenance is not being done, if those death certificates are being held up for some reason, but the Secretary of State is not being notified that a death certificate is being held up for whatever reason, and there are numerous reasons, that person is still inactive. They get mailed a ballot as a dead person, somebody intercedes, takes that ballot, casts that vote, they're no longer inactive. They're now an active voter. So there's an issue there. Additionally, there's no database. Well, there is a database. However, as we all know, there's been problems with DMV changing people's party affiliation, and no notification is given to anybody that has occurred until such time as you, the private citizen, check your own voter registration and discover, oh, how did my status get changed? I never did that. It's an ongoing problem, and I'm sure that the Secretary of State's office is aware of it, but we, the voters, are not being informed what's being done to correct that particular problem. Thank you, Mark.
Yes, sir. And just to quickly address that, again, ballots only go out to active registered voters. And just to clarify, I saw a couple of questions. The difference between an active and an inactive voter is simply that we have a confirmed address. So you can be an active voter, but not vote for a decade, and you're still considered an active voter. And if you are inactive and you're not getting a ballot sent to you, it's still possible to go to the registrar or clerk's office, show them your driver's license, for example, update your registration to show where your new address is at, and then you would be then become an active voter. I'm starting to stray a little bit from the proposed regulation, but the last thing I do want to say, just to reassure you that we get these records from Vital Record, the documents from Vital Records. Again, I mentioned every day. Sometimes there's a lag in the timeliness between the date of death and the receipt of that record. But we continue to get these, and we continue to now, this is something that we've developed as an internal process. We scrutinize the list of individuals who have, who have passed away to see if they have vote history. If they have vote history assigned to them, we compare that to the date of death. And if it was after the date of death, that goes to law enforcement for investigation. The goal, of course, is to prevent that from ever becoming an issue in the first place. Part of the reason why we've tightened up the processes and reinvigorated our discussions. But ultimately, again, there's a number of before and after type of assessments that we conduct to make sure that, again, we're keeping the rolls clean and investigating any anomalies appropriately. Ms. White, yes, ma'am.
Yes, so the information that Vital Records sends you is based on, can you hear me? Can you hear me?
Yes, ma'am, sorry.
Okay, my screen went blank. It's based on death certificates that they issue. Is that correct?
There's a point in their process where they have the information confirmed to be able to send us data on a deceased individual, yes.
Okay, so then that would lead me to believe that they are holding on to dead bodies for, I don't know how long, until they can get all their I's dotted and T's crossed before they issue a death certificate, even though the dead body's right there, because it's a matter of identification, right?
Again, ma'am, I'm sorry, I don't have the full details of all the situations that they experience. They receive information from coroners, from morticians. They collect information from the families, as I understand it. But outside of that, the detailed timelines, I'll have to refer you back to the Office of Vital Records.
Okay, that's the confusing part, because if you work backwards from where the voter registrar removes somebody from the rolls, you go back to the vital statistics, and then you say, okay, what do they need before they will report it to the registrar of voters? It would seem to me that all they need is a dead body, but then no, they won't. Dead body is not enough. They need to get verification of the identity of that body, and that could take quite some time. So there's a definite lag. I mean, how long? Yeah, you say you don't know it, but I mean, how long do they hold on to bodies before they'll issue a death certificate?
Again, it's been a minute since I've had to deal with a deceased member of my own family or friends. So I probably couldn't speak to that right now. But if possible, ma'am, again, I'll provide in the chat some detailed or some contact info for the Office of Vital Records. And I'm certain that they'd be able to help answer your questions.
That would be great. Thank you.
Yes, ma'am. At this time, is there any other public comment relating to proposed regulation R104-21? Okay, we did have some discussion about that, so I do want to just again clarify for the record that the draft in the notice will be amended so that the language will be changed from on or before February 1st of each year to on a monthly basis. Okay, hearing no further public comment. Regulation LCB file number R104-21P is adopted with the changes as mentioned on the record. Okay, at this time, I do see that it is 10:01. I'm going to take a quick break. We're going to pause to allow everybody to make a bio break, so to speak. If you would please rejoin me here exactly at 10:15. So a little less than 15 minutes, but we will resume at 10:15, and I'll put that into the chat as well so that everybody's aware of it. Thank you. All right, good morning, everybody. I've got 10:12. So again, just to clarify, 3 more minutes of our break and we'll start right promptly at 10:15. But just for those of you that are now joining us or anybody that's just kind of curious as to what's going on, we're on a break until 10:15. All right, good morning, ladies and gentlemen. For those of you that are just joining, my name is Mark Voloshin. I'm the Deputy Secretary of State for Elections. I work for Secretary of State Barbara Sagaski. Thank you for joining us today during these adoption hearings. We have 5 left, but before we get to those 5, I do want to remind everyone of a couple of quick kind of notes. First and foremost, we will be discussing the proposed regulations that were part of the notice. You have been provided a copy of the text from those proposed regulations. If those individual regulations were amended based upon public feedback that we've received since either during or since our workshop, I will call out specifically and explain in detail what those amendments are. You will then see the red line text, so to speak, prior to the Legislative Commission that is now scheduled for February 28th at 1 p.m. And I will also copy the link to the Legislative Commission site into the chat right now so that you all are able to see that. The Zoom call info or other details about physical locations for that meeting have not yet been published, at least as of yesterday when I looked. But I want to make sure that this is the site there that I just put into the chat where they will provide that information, as well as the details about how to submit public comment to the Legislative Commission relating to these and the other regulations that will be discussed during that Legislative Commission. So they will not just be talking about the 31 potential elections regulations, but also will be considering, I believe, other regulations from other agencies, possibly. Anyway. Two other things. So first and foremost, again, we'll be discussing the regulations, the proposed regulations today. Again, just a reminder, these are regulations. These are not statutes. These are in the Nevada administrative codes, not the Nevada revised statutes. These are regulations relating to in supporting the statutes, but in no way are they allowed to ever contradict or supersede statutes. Statutes are, of course, made by the legislature. These regulations, again, follow a parallel but different process, but are ultimately confirmed by legislators during the legislative commission. And again, that website also provides additional details on the process and additional points of contact if you do have follow-up questions, or there are specific processes and procedures. And then lastly, I do want to just address the need to be civil, please. As we continue and discuss these last 5 proposed regulations, both in your words, your oral spoken words, as well as in our chat. If you do have questions, please understand I'm using the chat to monitor when individuals want to ask a question. So if there are sidebar conversations, I encourage you to take them well, really out of the Zoom and into other forms of communication. I'm okay with you guys swapping phone numbers or names or whatever to continue those conversations. But please, again, be mindful that there are individuals who are using the chat to identify questions. And if there's back and forth, then I may end up not seeing those questions. All right, so that being said, I will open the adoption hearing on proposed regulation R105-21. R105-21. Existing law requires the Secretary of State to adopt regulations for the conduct of special elections in all cities and counties. This regulation provides that if a recall or special election is called in a county or city and will not be held on the same day as a primary election, primary city election, general election, or general city election is applicable, 1, the appropriate clerk must notify the Secretary of State of the election, and 2, the Secretary of State will confer with the clerk regarding, if applicable, the use of the system of approved electronic transmission established pursuant to NRS 293D of the locations 293D.200. B, the locations of polling places, including without limitation, polling places for early voting by personal appearance in vote centers. C, the locations of ballot drop boxes for mail ballots. D, a plan for the security of ballots for early voting. E, a plan for allowing members of the general public to observe the conduct of voting at a polling place. And F, a plan for the accommodation of members of the general public who observe the delivery, counting, handling, and processing of ballots at a polling place, receiving center, or central counting place. We did receive some feedback on that, but there are no proposed changes based on the feedback and discussions that we had either during the workshop or during or in writing. Again, if anybody has any at this time, I will open public comment regarding proposed regulation R105-21. If you are interested in providing public comment on R015-21, please go ahead and indicate so now in Zoom. Okay, I don't see anybody interested in making public comments. Okay, hearing no further public comment, no public comment at all regarding proposed regulation R105-21, I will close public comment. Proposed regulation LCB file number R105-21 is adopted and will move forward to the Legislative Commission. I will now open the adoption hearing for proposed regulation R106-21. Existing law requires that at least once a year, each county and city clerk and all staff members of such clerks whose duties include administering an election complete a training class on forensic signature verification that is approved by the Secretary of State. Section 2 of this regulation provides that 1, the Secretary of State will publish biennially a list of approved training classes, and 2, to be approved, a training class must include a written test on forensic signature verification. Section 3 of this regulation provides that with certain exceptions, each county clerk, city clerk, and all staff members of the clerks whose duties include administering an election must annually complete 1, a training class on forensic signature verification, or 2, a refresher class on forensic signature verification. Section 3 also requires each county or city clerk to annually 1, identify which members of his or her staff are required to take the classes, and 2, submit to the Secretary of State certificates of completion of the classes. Section 4 of this regulation provides that if a city or county or city clerk determines that any member of his or her staff whose duties at a particular election include checking the signature of a voter at a polling place or on a mail ballot has insufficient time to complete an approved training class on forensic signature verification, the clerk may authorize another member of his or her staff who has successfully completed such a class to provide to the person at least 2 hours of hands-on training related to checking the signature of a voter. Section 5 of this regulation prohibits a staff member of a county or city clerk from checking the signature of a voter at a polling place or on a mail ballot unless the person has successfully completed an approved training class on forensic signature verification or received the training described in Section 4. We received significant feedback regarding this proposed regulation and have adopted a change. There are a few amendments based on public feedback that the Secretary of State received. First, the deadline of April 1st, and to clarify, does not reflect the need for training to occur for primary, general, and special elections. So the language will be amended to allow for future deadlines prior to other elections. Second, Section 16 of Assembly Bill 321 states, at least once a year, each county clerk and all members of his or her staff whose duties include administering an election must complete a training class on forensic signature verification that is approved by the Secretary of State. Just so that you're aware, not all staff members, and that's either permanent or temporary, are necessarily hired by April 1st, which is part of the reason why we need to include additional dates relating to other elections. And while Section 4 of this proposed regulation does provide direction as to how those other staff members can be trained who are either hired after April 1st or who are unable to accomplish the requirement of receiving the signature verification training by April 1st, while Section 4 of this proposed regulation provides that direction as to how those staff members can be trained, we are removing the direction that one trained staff member may train another and will instead simply require them to receive the same training everyone else receives. This will further standardize the process to ensure continuity across the state. At this time, if anybody is interested in providing public comment on proposed regulation R106-21, please go ahead and indicate in Zoom now. Ms. Martinez, please.
Yes, thank you, Mark. For the record, again, Cindy Martinez, Vice Chair of the Washoe County Republican Party. I have to reiterate my discomfort with Section 4. I still think it's inappropriate to have peer-to-peer training on such a vital element of ensuring election integrity and making sure that signature verification can be accomplished. I do not have faith in peer-to-peer training. I've been in peer-to-peer training, and I know if you turn on the Zoom or you turn on the electronic online training, you can sit there and have your lunch and not participate. I don't know what the means are, but this is not acceptable. It further weakens the signature verification. And if the requirements for hiring temporary staff, quote, for a particular election, then the standards must be as high and as enforced for temporary staff as they would be for permanent staff. So there needs to be some accommodation and some adjustments made for that. If the requirement to verify signatures for permanent staff is that they have to complete this training, then it should be applicable across the board. I really don't endorse this. I don't support it. I'm very, very disturbed and disappointed to see that this is still standing. Thank you.
Ms. Martinez, I apologize. Just to clarify, Section 4 of this proposed regulation provides direction as to how staff members can be trained. We are removing the direction that one trained staff member may train another and will instead just require them to receive the same training everyone else has received. So just to clarify, your concerns about the peer-to-peer training have been heard. That is something that the Secretary understands and appreciates, and we are removing that language from the proposed regulation. So there will no longer be peer-to-peer training as a possibility. I apologize for not being more clear on that.
Well, I'm looking at the link that went out in the notification in January. Maybe I'm not looking at the most updated one, but section 4 says if a county, well, let's see.
Oh, yes, ma'am. So we did not provide the amended text yet. The amended text is coming prior to the legislative commission. So you're reading the right document. I don't want you to think that there's a different document that you're missing. But as part of the adoption process, again, because of the written feedback that we continue to receive, again, until even to be truthful, I haven't checked, but we probably received some in the last 30 seconds. This is one in particular that Secretary Sagaski agreed with and has struck from the language. So you're reading the right text, but I just want to clarify for purposes of this adoption hearing that we are amending the text to eliminate that peer-to-peer training requirement.
Okay, I'll take you on good faith that that's going to be forwarded to the legislature. Thank you.
Yes, ma'am. And this, again, specifically said for the record and providing in extreme detail so that you can hold me to it specifically. But yes, ma'am. Again, the written, there's a couple questions about the written changes. Again, those are still, and Mr. Ott, maybe you could provide a little more clarity on this, just if I'm missing the mark here. But we have the proposed text that you were provided as part of the agenda. Again, based on the public comment and the feedback we received during the workshops, when the secretary reviewed and we discussed that, this was one in particular that she agreed with. So by clarifying the language and what we're going to adjust for adoption, again, this is something I can't be general on. I can't just say, well, we're going to fix it. And like very specifically, there will not be a peer-to-peer training option for the record in this proposed regulation when it gets to legislative commission. And instead, it's simply going to say that all, the exact language was, all members of his or her staff whose duties, including administering election, must complete the same training class on signature verification that is approved by the Secretary of State. But yes, ma'am.
Yeah, and Mark, if you want, I can provide a little detail that may put some people to sleep on the reg process. So you'll see the attached link says proposed regulation. Those all get issued by the Legislative Counsel Bureau, who are the lawyers for the legislature who control the regulatory process. When Mark is talking about, the speed with which comments come in and their ability to sort of edit those things, the regulatory process allows the Secretary of State to make changes to the regulation up into the adoption hearing. The problem is the lawyers for the Legislative Counsel Bureau can't necessarily draft those changes immediately. So what Mark does when he wants to react to those comments timely is he says, I am making these changes, and when I adopt the regulation, the changes made on the record are adopted. So what he's doing is reading into the record the changes that he will then make and send to the Legislative Counsel Bureau so that they will be reliant on the words that he says here. So just some clarity as to why you don't have a written version. I know that's sometimes frustrating for people, but really it's to try to make sure that all of the comments can be considered and also respect the Legislative Bureau's role in drafting the final regulatory language. So just a little bit of background there.
Thank you, Mr. Rob. Yes, ma'am. Mr. Sackerson, please.
All righty. Sorry, I've got a call coming in, which I'll mute. Anyway, Ralph Sackerson from Elko County, and my comments also may already be superseded by changes, but they were towards section 3.1, and that again is a request of a stated and high passing grade, 80% or better. And section 3.2, I would request, as had others in previous sessions, that a refresher class also should require approval by the Secretary of State. Without regular use, deteriorating skills across time are fairly common, whether it's this sort of thing or just about any others of our skill sets. anyway, thank you for your time, for allowing my time.
Yes, sir. Thank you, Mr. Sackerson. I appreciate your comments. And actually, yes, sir. Ms. White, please.
Thank you. Are public observers going to be allowed to view the signatures, not just the overall general process from a distance? I remember we talked about having personal private information on the screen with the signatures, and we talked about possibly just isolating the signatures themselves so that public observers could see the signatures. Is that anywhere in the works?
Yes, ma'am. So certainly a lot of discussion going on about that. There's some possibilities of changes, but unfortunately, as it relates to this specific regulation, not something that I can really discuss or go into right now. But there is a lot of continued discussion about that process, and again, different methods for improvement.
Okay, and then the group or company or whatever that provides the signature training, are they certified, or how do they choose it? Each county just kind of finds an expert?
No, ma'am. So that's again also an ongoing process and part of the discussion. Again, we're rapidly approaching the primary, so there's some possible solutions that are being examined. But again, outside of the scope, I think, of this specific regulation, it will certainly make that. Again, the goal is again identifying a useful training program that does meet the requirements. And this is something too that frankly, again, whatever solution we come up with, for this first year, recognizing that this went into effect just on January 1st, I'm certain this is going to continue to grow and change, in years to come as well. So this is all part of our continued desire to improve processes, improve training, and to not just find a solution and then maintain it as the status quo.
Okay, thank you. And then just one last suggestion, when we're watching the poll worker actually do the signature verification, could they have some kind of marking on their ID to show that they have completed the training so that we know a poll worker has been trained? I mean, because how do we know if the person sitting there verifying the signatures has actually gone through the training and passed it adequately?
Yes, ma'am. I understand. I appreciate the suggestion. I'll see. I'll take that into consideration and see if there's something that we can do. Because beyond just again the idea being that a clerk would not allow somebody to be part of that process without having taken the training. But I see what you're saying. A verification, a visual verification. Yes, ma'am. Mr. Camp, please.
Yeah, Mark Camp, Republican candidate for Nye County Clerk. I can see in section 2, 1 and 2, it says that the Secretary of State will publish a list of training classes that are approved by the Secretary of State for county clerks. Again, it also goes on to say that the training class must establish a basis for determining a passing grade. In this case, I had made this comment before, and that I believe a passing grade has to be 100% verification, because when somebody gets it 20% wrong, I don't think that's acceptable. I do believe that there are training courses that can be identified that allows a person to go back and get it right until they considered it 100% passing grade. Since the Secretary of State is the one who looks to me solely responsible for identifying and publishing this list of courses, if the regulation at a minimum establishes that there should be courses that allow for 100% verification that a person can establish a passing grade and identify signatures that are good and bad, I think that would help not only me, but the general public feel comfortable that the process is working and that they can have more confidence in our elections. Thank you.
Thank you, sir. Any other public comment relating to proposed regulation 106 R106-21?
This is Darla Lee. Can you hear me?
Yes, ma'am, I can.
Thanks. I'm just concerned that, is this something, this signature verification and taking classes? I'm assuming this has been going on for other elections, correct?
No, ma'am.
This is the first time that there's actually been a requirement to have a signature verification. That's very disturbing
This is
for
the-
past elections.
Yes, ma'am. So this is the first time there's a requirement for it. I guess I should have clarified that the training does occur. Again, it's worthwhile to mention, right, that the statutes point to the individual who's ultimately responsible for verifying the signature is not a poll worker, but in fact, the clerk or registrar themselves. So again, just to be mindful of the process, the poll worker who's involved in this process, again, if there's a question, it goes to the clerk and registrar, and they're ultimately the ones that will send it off to signature curing. So again, the levels of responsibility I think are important to clarify, because there's a statutory requirement for clerks and registrars that does not extend down to the poll workers. But again, as now that the requirement's been clarified, again, that the training is being identified as well to make sure that we're providing this to the appropriate individuals prior to the election cycle. Yes, ma'am. Again, for what it's worth, right? It's also, you know, when you think about years past, with the exception of 2020, before that, there were, when you think about the number of signatures that were actually verified using the old absent ballot process, we weren't talking about thousands, we were talking dozens, you know, more or less, because of the absent ballots, and those signatures again still had to be verified. So it was a vastly different requirement, which is again ultimately what led to this new requirement out of Assembly Bill 321 to ensure the security of the election process going forward.
Okay, so just to clarify, the poll worker, which is what I assumed, is not doing signature verification. But when they're looking at a person coming to vote and the signatures are vastly different, then they would pass that information on to the manager, and that would go forward to someone who would do the actual verification, correct?
Yes, ma'am. So when ultimately, again, as a poll worker, whether it's with a mail ballot, when they do that initial comparison, if it's not crystal clear that the signatures match, then that right there is if it's not crystal clear, then it goes to signature curing process, which again, they pass it off to the clerk or the next supervisor to get it to the clerk. Clerk confirms, yep, there's a question, goes off to the signature curing process, again, to ensure that is in fact the voter's ballot that they submitted.
Okay, and just a quick question about the training. So you have done training before. I'm curious as to how many hours this is involved in this training, since the section that you've taken out apparently only required 2 hours of hands-on training. So what is the typical training for signature verification? How many hours is that?
So that's still being determined. Again, the part that we took out was the 2 hours of peer-to-peer training. The idea there in that initial proposed language was the idea that, again, with a trained worker and an untrained worker, you know, it said 2 hours. But again, depending on the county, there may not be, you know, ballots to actually even review for considerably more than 2 hours. So it might take a couple days to rack up the 2 hour training requirement, which is what was part of that requirement relating to the peer-to-peer training. By having everyone take the same standardized training, again, whatever level of time that's required, that will be at the very least then consistent going forward.
Okay, thank you.
Yes, ma'am. At this time, is there any other public comment relating to proposed regulation R106-21? Okay. Then just to clarify for the record, so we will be amending the text to remove the peer-to-peer training. And we will clarify that everyone will take the same standardized training. And then one additional add, again, that I thought was in my notes, but neglected to mention as well. But again, Mr. Sackerson reminded me of, we will clarify that the refresher class is also required to be approved by the Secretary of State. Completely agree there as well. Again, refresher courses in the interim years still extremely important, still must be standardized, especially as they relate to the possibilities of special elections, which oftentimes are related to recalls. So again, any election carries the same importance across the state. So even refresher courses will be required to be approved by the Secretary of State. Okay, if there's no additional public comment relating to proposed regulation R106-21, I will close public comment on R106-21. And regulation LCB file number R106-21 is adopted with the changes as mentioned on the record. I will now open the adoption hearing on proposed regulation R107-21. Existing law requires, with certain exceptions, a county or city clerk to prepare and distribute a mail ballot for every election to 1, each active registered voter in the county or city as applicable, and 2, each person in the county or city as applicable who registers to vote or updates his or her voter registration information not later than 14 days before the election. Existing law also authorizes a voter to elect not to receive a mail ballot by submitting to the county or city clerk a written notice which must be received not later than 60 days before the elections. Section 2 of this regulation authorizes a registered voter to elect not to receive a mail ballot by submitting such written notice to 1, the Secretary of State, who will notify the applicable county and city clerks, 2, the county clerk, who will notify the applicable city clerk, or 3, the city clerk, who will notify the applicable county clerk. Section 2 further provides that if a voter has previously elected not to receive a mail ballot, the voter may submit written notice he or she wants to receive a mail ballot in future elections. Section 3 of this regulation provides that if a registered voter updates his or her mailing address in the voter registration information after the date on which a mail ballot has been sent to the voter, but not later than 14 days before the election, county or city clerk, as applicable, must cancel the first mail ballot on or before the 13th day before the election, send the voter a second mail ballot to the updated mailing address. There was no additional amendments based on public comments to this proposed regulation. So at this time, I'll open public comment relating to proposed regulation R107-21. If you're interested in making public comment, please go ahead and indicate in Zoom now.
Gift card to use for all your meals when you're down there, and you guys have an entire year to take that incredible trip. Does that sound good?
Ms. Martinez, please.
Yes, thank you. This is, thank you, Mark. This is Cindy Martinez for the record again. On just a brief note, and he's going to be singing to the choir, that the opt-out, what is that background?
I don't know. If everybody could please double check that they're on mute, please, just so we don't have any background noise.
Thank you. Yeah, it's still going. When one opts out from receiving a mail-in ballot, they are relegated directly to voting on the electronic machines. There's no paper trail except that audit receipt that scrolls, at least here in Washoe County, that scrolls on the side of the machine where you can verify, which I always do whenever I cast my vote, but there really is no paper trail. That can't be changed. Obviously, this is in the NRS that was passed by legislature, and you're codifying or adopting regulations. I just want to put that into the record that still remains the shortcoming in our election process and a vulnerability for the voters. Thank you.
Thank you, Ms. Martinez. At this time, is there anybody else with interested in making public comment relating to proposed regulation R107-21? Okay, if not, then I will close public comment relating to proposed regulation R107-21. And hearing no further public comment, proposed regulation LCB file number R107-21 P is adopted and will move forward to the Legislative Commission. At this time, I will open the adoption hearing for proposed regulation R108-21. Existing law requires a county or city clerk to allow members of the general public to observe the counting of the ballots at the central counting place if those members do not interfere with the counting of ballots. The central counting place is the location designated by the county or city clerk for the compilation of election returns. This regulation, 1, authorizes with certain limitations any person to observe the processing and counting of ballots at the central counting place. 2, requires that before a person may observe the processing and counting of ballots, the person must sign an acknowledgement that certain behavior is prohibited at the central counting place. 3, authorizes under certain circumstances the city or the county or city clerk to limit the number of persons observing the central counting place. 4, authorizes under certain circumstances the county or city clerk to remove a person from the central counting place. And 5, requires a person to wear a name tag while observing the processing and counting of ballots. We did receive significant feedback regarding proposed regulation R108-21 as well. And there is one amendment that again, I'd like to present to you for discussion prior to opening it up for public comment. When you look at the text of section 1, subsection 4, specifically subsection 4, section 1, subsection 2A4. This is in regards to the acknowledgement that the individual has to sign, recognizing what he or she is prohibited from. Number 4, the text says arguing for or against or challenging any decision of a county or city election personnel. We are proposing to remove that language and replace it with the text interfering with the statutory duties of county or city election personnel. Again, removing the text arguing for or against or challenging any decision of county or city election personnel and replacing it with interfering with the statutory duties of county or city election personnel. At this time, if you're interested in making public comment relating to proposed regulation R108-21, including this amendment, please go ahead and indicate so now in Zoom. Mr. Sackerson, please.
Clicking the wrong mute button there. Ralph Sackerson, Elko County. I find section 1.2A2 a little incongruous. Observation using electronic devices avoids a considerable amount of potential disruption because you're essentially restricted then to using clipboards, notebooks, as well as taking the time required to document whatever events you're observing. To document them in writing is an awful lot longer than using a cell phone or an iPad or whatever to, photo a signature or simply photo whatever event's going on. In practical terms, section 1.2A2 as written conflicts with section 1.2A5. That's basically the gist of my concerns. Thank you for the opportunity to speak on it.
Yes, sir. Thank you, Mr. Sackerson. Ms. White, please.
Thank you. In the digest, it says authorizes the county or city clerk to limit the number of persons observing in the central county place. that seems to disenfranchise a whole bunch of people. I mean, he or she can say, no, I just want 3 people in here. Well, what about the rest of us who want to do it, who want to observe? I don't understand why that's still in their power to do it. It seems like they're taking away rights that are not within their power to remove. So no modifications were made to that?
No, ma'am. Again, again, all of these regulations, again, were taken very seriously and considered. This one in particular, again, relates back to the requirement to provide an observation plan. That is something too, that those observation plans going forward will receive more discussion and scrutiny. Again, and to reinforce, the secretary and all of the clerks and registrars are committed to having as many people as possible in these processes. They all want to be transparent, despite what maybe you're reading in the news or otherwise. So again, the ability to limit based on the physical locations and those sorts of factors to remove the possibility of interference in the processes is something though that ultimately, again, while certainly heavily considered, is something that still needs to go forward. Yes, ma'am.
Well, I understand your comment that you believe that they want full transparency and want the public in there, but I don't have that trust. So I would like it documented in regulations. I mean, I don't have that trust in their desire for transparency and public involvement. And this is just giving them carte blanche just to say whatever they want, to limit.
Yes, ma'am. I've taken note of your comments. Ms. Guerrero, please.
For the record, my name is Matilda Guerrero. During the 2020 general election, our coalition partners, Everyday Nevadans, and I had the privilege of observing the mail ballot verification processes here in Clark County, and we can attest to the veracity of the process and to the strong commitment of the election workers to ensure that our election results were properly certified. Mr. Gloria's team answered any and all questions observers may have and ensured that folks can observe the mail ballot processing from tabulation to the signature verification process, from the Greystone building and even in the physical elections department. I did want to say though, we all had the opportunity to watch, but to counter the effect of there's not that much room to do all these things, especially within COVID times, folks were able to take turns tagging in and out so everyone could see something. And definitely on behalf of the Let Nevadans Coalition, we support the amendment to Section 1, subsection 2A. Very important to make sure that we're putting on the record that we cannot disturb our election workers while they're doing something very important.
Thank you, Ms. Guerrero. Mr. Nellis, please.
Well, Mark, I was personally down there in 2020 at the Washoe County Registrar observing what was going on. And I can attest to you the opposite of what the previous lady said. We had a hostile registrar of voters, and her assistant was hostile. And the other thing that I observed, we're working on putting poll watchers at the polls. This is what happened. The Democrats shipped in people from San Francisco by the busload, and they would come in and one would say, I'm a Democrat, because there'd be 2 chairs to sit in. And the other one would say, I'm an independent, and there's no verification. And then those seats were full, so we couldn't get our people in there. And the at the registrar's office, there were 3 chairs. Oh, that's really nice. She gave us 3 chairs. The same thing happened there, but we were able to get a hold of one of the chairs and do a lot of watching. But what happened also, so first of all, I'm against, I mean, there should be stated how many chairs it will be, something like 4, so that people can be allowed from different parties and different independent groups to be able to be in there. Maybe it should be 6. Because if you just leave it up to the registrar, if you have a hostile registrar, then you're at their mercy. And what I did is I said, hey, how come I can't see the signature verification process? Well, oh, there's private information on that screen. That sounds like a really great excuse to block people from actually observing. You know, I believe that, doesn't the law or the statute say that we are supposed to be able to observe? And so they use that justification to block us. And then if we argue and say, no, the law says blah, 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 they'll say, oh, you're interrupting our process now. You're hindering our ability to do our job. That was what Miss Spicula said. So, oh boy, just shut you down right now and get you out of there. And I actually agree with that previous man's comment too, that we should be able to use our cell phones to record. I guess maybe we should just bring a camera in and not our cell phone. But there were things that I saw I would have liked to have actually recorded. So, you know, you can see a person looking back at it could actually see what actually happened and who it was and said and did it. And there were things I didn't realize that were probably were illegal that were going on. For example, we had a husband and wife Democrat educators that were adjudicators, I'm sorry, that were adjudicating the ballots also. And the wife gal, she was hostile towards me also when I tried to look at what she was doing. But so yeah, there's lots of problems.
Thank you, sir, for your comments. And just to clarify, this again, this is not the end all be all. This regulation, upon again, assuming it is adopted and then moved forward by legislative commission. Again, the plan is not to just stop. We are continuing to again discuss with other states, other counties and jurisdictions the processes and what other locations do. This isn't a and I believe we had a discussion about this during one of the previous workshops, but just to give you a quick a summary of that. It's a challenging problem because not everywhere in the state has the same physical spaces that Clark County does, or Washoe for that matter. So mandating, X number of seats may not physically be possible in some locations. There's discussion and ongoing consideration to maybe, adjust it. You probably have seen in some of our statutes and regulations, for a county above 500,000 residents, you must do A, B, and C. But if you're above 100,000 to 4,999, you have to do, D, E, and F. And then for appropriately scaling based on the resources of each location. Because again, the intent is very much to facilitate observation and transparency. There are also discussions that we've had about how to adjudicate those sorts of seats. Do we say one seat for one major party, one for another, and then one for a nonpartisan and independent? Do we limit it to ballot access? Do we limit it? Do we make if you're a major or minor party in Nevada, do we give all of them seats? And then what happens if someone doesn't show up? Are we allowed to let somebody from a different party in? And when we discussed this with the clerks, it became very apparent that when they, certain locations did try that sort of, let's try to make it as fair as possible, and it became a full-time job where there were, folks. Well, wait a minute, I don't recognize her from my party, but I thought she said she was this. And then, is it up to the clerks to try to confirm or party affiliation? So there are still ongoing conversations and discussions about this exact topic. Do I think that we've mastered it and have figured out the exact solution? I don't, frankly. I think we're going to continue having discussions about this. I think we're going to continue, refining the observation plans that the clerks submit to help, again, provide transparency to the public and to continue this discussion to try to get to a closer point where you mentioned maybe, the parties being involved in appointing who their observers are. but still, there's going to be high school students. There's going to be people from out of town, international observers that are going to want to come. How do we, balance their requirements too? So it's there's a lot that goes into it, and it's certainly a lot to consider, and a number of different requirements that we're being very careful to not prevent or block when we look at this important part of the process. So all that to say, your comments are noted. I understand your concerns, and I do appreciate your involvement today.
Thank you.
Ms. St. John, please.
Hi, I'm Elaine St. John from Lyon County, and I'm also concerned about equal representation. So I would like to see something where we have an equal amount of people. The other thing that concerns me is some of the verbiage on I believe it's kind of leaving it up to the clerk's discretion too much. And I would point to item 3A, where it says public safety. Public safety, I feel, is too broad of a statement. Perhaps it should read something like limit to the number of persons pursuant to the fire marshal's occupancy limitations. I don't want to see any limitations at all. And I think public safety does kind of limit that. Thank you very much. I appreciate your time.
Yes, ma'am. Thank you. Ms. Thomas, please.
Thank you. I think I stated at the workshops that Washoe County, I was able to get Washoe County to employ a reservation system. So basically we had a sheet with 3 seats. One could be Republican, one could be Democrat, and one could be other. And it was on an hourly basis. So the folks had to rotate out of there if somebody was wanting to come in, and everybody had to put their name on the sheet. So therefore it took the responsibility off the manager of trying to herd cats, so to speak. And but I did mention at the workshop if there was some way that the Secretary of State could have some type of database that we could pull up as managers to verify that these people were actually registered with those parties. I guess we could just go up and pull up their registration information to see if they are, but again, that's time consuming for us to have to do. And then we also have to have them sign this form, and a lot of them will tell us, well, I already signed that form at another location. And then there's this battle on whether or not they have to sign another form. So it's just, there was petty arguments that really didn't need to be wasting our time with. Was there any more discussion by your office and trying to get a database at the state level like that?
Yes, ma'am. Oh, absolutely. Again, to be perfectly blunt, the development of an IT system is a far more long-term project than you would probably prefer to hear. The resources that we have from an IT perspective are dedicated to a number of projects that are very specifically related to past legislation. But yes, ma'am, again, and I do remember your comments from the workshop, and I appreciate that. And we did follow up. And again, there's, like I said, ongoing discussion about, how we can maybe try to improve these processes, and further discussion between the clerks for sure as to a means to balance individuals, in some cases citizens, in some cases not, that are interested in observing, but finding a way where it's not as time intensive for the clerks and their staff. So yes, ma'am, again, ongoing discussion, but without going into too much detail in our current personnel. Yes,
Was there
ma'am.
any discussion on maybe trying to encourage the counties to have like a reservation list that observers must be responsible for signing on to themselves? It's not the manager's responsibility to manage their sign-in sheet, but their responsibility to sign themselves on these sheets so they can reserve their own seats?
There's a number of things that I know the clerks are considering and looking at trying in the primary as a means to test as we get closer to the general. Yes, ma'am.
Okay, thank you.
You're welcome. Ms. White, please.
Thank you. All of these headaches about observers and seats and who's truly registered as what, they could be solved in one fell swoop by getting a camera focusing on the signature portion only of what these verifiers are looking at, and putting it on a monitor, a large monitor in the room where anybody and everybody in that room could see the signatures. That would not require heavy IT expense or time. I could do it, and I'm not a super techie. So I would suggest that you include that in here someplace, and the urging of county clerks to include large monitors of the signature portions only of what the poll workers are doing as they're verifying these signatures. Thank you.
Yes, ma'am. Thank you for your comments. At this time, are there any other public comments relating to proposed regulation R108-21? Okay, if I don't see any more public comment, then I will close public comment on proposed regulation R108-21. And hearing no further public comment, our regulation LCB file number R108-21 is adopted with the changes as mentioned in the record, specifically, again, changing the text to replace the phrase arguing for or against or challenging any decision of county or city election personnel with the text interfering with statutory duties of county or city election personnel. LCB file number R108-21 is adopted with those changes as mentioned for the record. And we'll move forward on to legislative commission. I will now open the adoption hearing for proposed regulation R109-21. Existing regulations require after each election, the county clerk to conduct a post-election certification audit of a certain number of voter verifiable paper audit trail printers, known as VVPATs, that are randomly selected to ensure that the paper record produced by a VVPAT accurately records all votes cast by voters on a mechanical recording device. A VVPAT is the device attached to a mechanical recording device, and the paper it prints to record all votes cast by a voter for any and all candidates, and for or against any and all measures enabling that voter to visually verify that the mechanical voting system has accurately recorded the votes of the voter. This regulation provides that if a discrepancy of 4 or more votes is discovered during the post-election certification audit, the county clerk must immediately notify the Secretary of State and investigate the cause of the discrepancy. If the discrepancy cannot be resolved, the county clerk must randomly select an additional number of mechanical recording devices with attached VVPATs used in the election to audit. This regulation also requires the county clerk to include in the audit results transmitted to the Secretary of State and explanation of any discrepancy discovered by the county clerk, and if determined, an explanation of what caused the discrepancy to occur. Now, there was, again, a significant amount of feedback regarding this proposed regulation. As I mentioned early on, though, again, this is one where we don't view this as an end-all be-all. I suspect this one will likely come up again in a year to change. But being uniquely aware of the requirements the clerks now have based on the number of legislative changes coming out of the last legislative session, while there is an additional requirement here, it's not as, I think, strict or as big as many of the suggestions wanted it to be. But again, the goal here is increasing compliance, increasing transparency, and steadily moving towards additional audits and additional, requirements. But instead of making a 50-foot leap forward, this is a much more measured, about a 3-step forward movement in the right direction. That being said, there were no additional changes to the proposed text of proposed regulation R109-21. If at any time, if you are interested in providing public comment on this proposed regulation at this time, please go ahead and indicate by raising your hand or in Zoom now. Ms. White, please.
Would you please clarify for me what the VVPAT is?
Yeah,
and how
absolutely.
it's created and where it's counted, all that. Thank you.
Yeah, certainly. And without going into too much of a history lesson, a lot of this, the purpose of the VVPAT, it came about because of concerns in how a ballot was recorded. And when you think back, over multiple decades, right? So once upon a time, people having to physically write on a ballot. Well, the handwriting was kind of the problem then, trying to decipher who they were talking about. So we worked towards printed ballots, once upon a time. As those printed ballots, again, got more and more clear and concise, You may remember out of the 2000 election, right? The concept of hanging chads, where depending on how people indicated their voter preference by pulling a lever or trying to mark by hand, that created significant concerns too. So ultimately, the direction that the EAC and a number of other organizations kind of encouraged vendors towards was the idea where a voter is able to provide an indication of who they want to vote for on a screen, and it is then recorded on paper, which is why you may have heard, and it might have been a bit confusing when people say here in Nevada, well, we do have paper ballots, because in a very legitimate sense, we do have a paper audit trail related to what's on the screen. When you vote using a Dominion machine here in Nevada, any of the 15 counties that use Dominion machines, and only 15 counties, by the way, do. Carson City's system is not made by Dominion. It's made by a company called ES&S. In Lander County now also uses the ES&S system. But when you use one of the 15 counties Dominion machines, there's a screen that you're looking at. Your vote's actually recorded in 4 locations, one on an internal hard drive, twice on a USB drive, and then the 4th way is in that voter verifiable paper audit trail. So that when you hit the 5 individuals that you wish to cast your ballot for, you are able to look down and confirm that information on the paper is matching what's actually on your screen. As people vote on the machines, again, there's a digital record now as well as a paper record that can be compared to make sure that the machine is in fact recording exactly the right way and that there's no issues or discrepancies. And I will tell you, because this is a question I've asked and I've dug into talking to my counterparts in other states, that there have never been discrepancies with Dominion voting machines between what's on the screen and what a voter says, these are the people I want to vote for, and what's on that paper audit trail as well. The other 2 systems used by ES&S in Carson City and Lander County are what's called a direct recording equipment, or a DRE. That's as I think was mentioned in the chat briefly, a slightly different process where there's a special type of paper that you have when you walk up to the machine, you slide it into the machine, you select who you're interested in voting for, and then it basically prints it out onto that special paper that you get back. You then walk over to the tabulation machine, slide your ballot into that tabulation machine, and it records everybody that you want to vote for as it stores that document. Again, that process gets away from the concerns about, who are you circling certain things or crossing things out, or those sorts of issues. But ultimately, the VVPAT, again, is a very important part of our process because it enables a voter to confirm exactly what they want to have their ballot cast for, who rather they want their ballot cast for, what the answers are to the questions that they're asked, both digitally as well as on the paper audit trail.
Okay, and then the follow-up question is the random selection, is that by precinct? Is it by county?
By county.
It is by county. Okay, and where and when is that random selection made? I mean, so in regards to the specifics of the post-selection certification, there are time periods that these have to be done with. Again, between the closing of polls, and really it's closing of polls, right? But then also, they're focused on the 4 days to receive mail ballots, 2 more days of signature curing. At that point, right, the clerks, again, just to highlight how much work they have, a lot of folks think that election day is the finish line. It is not the finish line. 4 days of receiving ballots, 2 days of signature curing. They have to prepare paperwork for their Board of County Commissioners while concurrently preparing risk limiting audits and conducting risk limiting audits, as well as conducting some of these post-election certifications to provide back to the Secretary of State information indicating that the machines, again, were audited appropriately. This is also one of a couple different audits. There's also audits before the election. There's daily audits to make sure that the number of voters, again, matches the number of ballots cast, and they identify those discrepancies as well. So there's a tremendous amount of oversight to these processes. Yeah, thank you for that. But my question is really, how do we verify that it's random? I mean, just because the county clerk says, oh, I picked a couple here. I mean, how do we know? When are they picking that random selection? And then just to kind of counter your support of Dominion, we cannot see what's happening inside that source code. So If they say A equals A, there's no way for me to be sure about that because I can't see the source code. And then last, our registrar, Spicula, she certified the election results with, I think it's 3 hard drives that were missing. I don't know how she could have done that with 3 hard drives of votes not counted. Thanks.
Yes, ma'am. Ms. Martinez, please.
Yes, thank you, Mark. So again, for the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. And yes, I would piggyback on what Valerie White just reported, is that here in Washoe County, our election was corrupted. There's no other way to describe it other than to say it was corrupted. When you have missing hard drives, regardless of whether you have regulations that purport to be able to reconcile a paper trail to that which is electronically recorded inside a machine that we do not have access and cannot analyze and verify the source code, then you cannot assure us that our election is secure and that the regulations will ensure that there's accountability through random verification, et cetera. And we'll get on, I guess, later into the hearings as the week goes on with the Nevada Gaming Control Board oversight with certification. But you cannot, regardless of what you put on paper, and you're stuck between the legislature, the citizens, those of us hearing this record, we understand that, so don't take this as a personal attack, but we need to make sure that our sincerity and our emphasis and concern about how our elections are being stolen, subverted, must be made abundantly clear to those that are seeking to impose governing regulations over the election process. I have no faith in that. The investigations that have been conducted since November of 2020 have established that these machines are not secure, regardless of what the paper corresponding to the vote that I may place on one of these machines may be. There is documented evidence that these machines are manipulated electronically. You couple that with the fact that hard drives are missing, and a lack of accountability and the veracity inside the respective county clerk's offices. But we have grave concerns. I appreciate that there's an effort by the Secretary of State to try and tighten up these processes, but my concerns are not allayed by any of this process. I appreciate that we're being able to articulate our concerns, but ultimately, until we bring our election process back down to the precinct level with voter ID, with paper ballots, and local accountability, where the power of the people properly resides per the Constitution, this process will continue to be subverted and stolen from us. Thank you.
Yes, ma'am. Thank you for your comments. Mr. Nellis, please.
Well, I'm in full agreement with what Mrs. Martinez said. My question for you, Mark, is have the machines ever been verified, their accuracy verified by counting the actual paper ballots that you said are accurate? I don't think that's ever been done. And as a matter of fact, when I was at the registrar's office, the rolls for the paper ballots were just tossed into a big bin. I'm not sure if there's any security for that. It didn't look like there was any security. They were just sitting there. They're like trash, basically. And so, do you know if it's ever been done?
Again, you're saying specifically that the number of ballots,
yeah, someone has actually taken the tapes, right?
Right.
I don't know how you would do it. I don't think you could scan them. You'd have to do it manually. And counted, the votes on the tapes, and let's say for Washoe County, and that would be an interesting exercise, I think, and just see if it really matches the machine, what the machine count was. Do we have till October to do that or something like that? Because supposedly all that stuff's supposed to be kept for 10 months after the election, right?
So yes, sir. It's maintained. There's a federal and state law to maintain election documents relating to an election for 22 months.
Oh, 22, that's right.
There's a limited window of time that it's basically available for access outside of a court order, and that's specifically to facilitate recounts and election challenges. That is an interesting proposal, though. I see what you're saying.
Well, the question is, I mean, how do you guys know these you said authoritatively that they match. I mean, how do you know they match? I mean, has anyone ever put it to the test? I think if you put it to the test, just in this last election, there'd be some big surprises, and you'd probably be throwing away all these machines. That's my opinion.
Sure, I understand.
Yeah.
Well, thank you for your time and your comments, sir. At this time, is there anybody else that has proposed or a public comment relating to proposed regulation R109-21? Hearing no further public comment, I will close public comment relating to regulation LCB file number R109-21 and proposed regulation LCB file number R109-21 is adopted and will move forward to the Legislative Commission. This time on the agenda, we are at the point where this is an opportunity for public comment to matters regarding matters other than the previously listed LCB file numbers. Comments will be limited to 2 minutes per person. If anybody is interested in providing public comment about a matter not on the agenda, please go ahead and indicate so at this time. Ms. White, please.
Could you clarify what you mean when you say this will be sent on to the Legislative Commission?
Oh, yes, ma'am, absolutely. For the regulations we discussed today, some of which the text that you have in front of you has not changed. Others, the text has been amended as I described on the record. Those changes will be implemented as described, and then we will forward this. It's part of a packet of information that goes to the Legislative Commission prior to their February 28, 1 p.m. Meeting. Yes, ma'am.
So you mean
in that I mentioned that because there is an option, and again, it has come up before where if because of public comment, if because of a certain point of contention or discussion, it's possible at this point, even during an adoption hearing, to not move forward on a proposed regulation. So there is an option where that proposed regulation would not move forward and would not be heard by Legislative Commission.
okay, so whenever you said that today, it just means that the language as it exists right now is what the Legislative Commission is going to look at.
For the, I think it was 5 that were not amended, those 5 will go forward as written. The other, I think it was 6 that I described that do have amendments. Again, that I was being very careful in how I phrased and what I explained. Those will be fixed, and then that corrected language will be provided to the Legislative Commission. Yes, ma'am.
Yeah, it would just be helpful. I know you took great care to read it carefully what the changes are, but it would be nice if we would be able to see that in some way. Do you have any of that language available for tomorrow's workshop that we could look at it right now?
No, ma'am. I'm sorry, I don't. Again, it is mentioned by Mr. Ott, just in part because of the timelines for the folks at Legislative Control Bureau to apply these changes.
Well, you understand how, we're supposed to have 72 hours before a meeting notice so that we can look at the agenda, look at the materials, et cetera. So this workshop is coming up, but we're not given any advance opportunity to review the language, the proposed new language. And that's what makes it difficult because we're doing all this on the fly. And this stuff is not easily digested. It needs a little bit more time. And even though, you're very patient, it still is inadequate to let us really digest what's written, the modifications.
Yes, ma'am, I understand. And for what it's worth, again, it's my understanding that the Legislative Commission will provide that at least 3 days in advance as well, or possibly earlier, as I understand it. And certainly if we get that amended text back, we will certainly make it available to the public as well. In fact, I will send you the link right now so that if we get it, you will know where to find it and where to look.
You're sending the link to what again? I'm sorry, I didn't catch that.
Yes, ma'am. So the, 1 second, we have a website that we put together that provides information regarding our elections regulations. Right now, you'll just notice that those have the original notices along with the videos, the links to the videos of the workshops. We'll put the link to the video of this hearing up there as well. If we get any amended text back prior to the Legislative Commission and are able to make that available to you, then this is the site we will put that on, and I will indicate there on the website so that you're able to see it and have a chance to review it before the Legislative Commission.
So you're going to post it on this chat right now.
I just put the link to the elections regulation page in the chat. It's third from the bottom now. And that link, when you go to it, well, it's got the 2022 proposed regulations. And that's where, again, depending on the timeline that we get the amended text, that's where I will ultimately post it. If we don't end up getting it back until, frankly, the public does before Legislative Commission, then when I finally do get it, that's where I'm going to put it for sure. Does that make sense?
Yeah, it's just not, it makes it all very rushed, but thank you for posting the link.
Yes, ma'am. Ms. Martinez, do you have another question or comment?
Yes, sir, I do. Thank you, Mark. For the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. I would respectfully ask you, Mark, and Mr. Greg Ott, if you would be prepared in the next couple of meetings, if you would assemble the information to answer our questions when the regulations come up regarding the oversight provided by the Nevada Gaming Control Board. There's anecdotal information we're gathering from different points and former co-workers of mine regarding who is actually performing the inspections, what the means of inspection is, the paper trails, and to whom or to where we can submit a public records request to review that review and approval process that's being conducted by the Nevada Gaming Control Board. Now, one of my friends here had received information from your office outlining what the Gaming Control Board was responsible for performing. And what I found interesting was the very broad language that, quote, members of the Gaming Control Board were responsible for inspecting the machines. And that's just a paraphrase. Now, anybody that is not aware here that the Gaming Control Board is comprised of 6 divisions with over 400 employees. The one division specifically tasked with electronic review and has the electronic engineers purported to, I would assume, conduct this investigation are in the technology division. My friend, former worker there, tried to talk to the chief of technology division, who has so far managed to escape answering any questions. Now, having been an employee of the Gaming Control Board for over 23 years, this is very concerning to me. So if you would please be prepared to answer with as much specificity as possible questions that we will have coming up in these hearings in the next 2 days on those specific points on what the Gaming Control Board is actually doing, who is doing it, where is the paper trail, where can we access that through a public records request, because we wish to review the veracity of the election integrity being asserted or being assured supposedly by the Gaming Control Board. And that gives me great heartburn, considering I did devote almost a quarter century in service to the state with that agency. So I would like some clarity on that. Thank you.
Yes, ma'am. We'll see what we can do. Oh, yes, ma'am.
If you're talking to me, yeah, no, thank you, Cindy, that was good. But if you could also provide the qualifications of those individuals, the job titles of those individuals who are doing the certification of the machines and the system. Just to know who they are. Do they really have qualifications that are up to the level needed to do those certifications? Thank
yes,
you.
ma'am. And again, I'll just for expectation management, we'll certainly discuss this and see what's available. I don't have the ability, I mean, outside of directing you maybe to who in GCB you could provide that information or request to. I'll certainly find out as much as we can provide about that process, and we'll be prepared to discuss it as applicable for future regulations hearings.
That would be helpful. Thank you.
Mark, if I may further comment on that.
Please.
Is I understand that you're what you just said, but I think what's really clear is that the information that is on the Secretary of State website, as well as the Clark County site, is indicating that the Gaming Control Board is providing oversight, and it's being referred to by the Secretary of State. So I, as well as the citizens, are ultimately going to hold the Secretary of State responsible for that information. So it's, and I know how the records request function works inside the Gaming Control Board, and it's extremely tightly controlled, very tightly controlled. So I'm asking you as a concerned citizen representing our constituency that we're respectfully asking you to have that information available to us, because I know what kind of a wall we will run up against inside the Gaming Control Board. Thank you.
Yes, ma'am. I understand. Thank you.
And I have another question. Does the Gaming Board Commission offer subcontracts to other companies that would be involved in the verification of the system? And if so, can you provide us some details on that? If actual personnel, Gaming Board Commission personnel, are not doing the actual technical verification, are they subcontracting it out to other vendors? And if so, who are those vendors?
I understand. Yes, ma'am. Okay. I'll see what I can find out, and we'll be prepared to discuss it as applicable.
Thank you.
At this time, is there any other public comment not related to an item on today's agenda? Okay, in that case then, as a reminder, this adoption hearing is not the end of the regulations process. Following the completion of this adoption hearing today, the next step will be revision of the text for those applicable recommended proposed regulations rather prior to the Legislative Commission. And then the Legislative Commission itself is meeting on February 28th at 1 p.m. And again, I will put into the chat the link to the, to the Legislative Commission coming up on February 20th at 1 p.m. Otherwise, that's all I have for today. I appreciate your time and comments. We have another one tomorrow if anybody is able or interested in attending. Otherwise, I appreciate your time, and we'll talk to you soon. Thank you. Ms. Thomas, is that something?
I was just going to ask if you were related to Chris. It's just your name is unusual.
It is, in fact, unusual. And there's a surprising number of Voloshians across the country, I think you might find. So yes, ma'am, we are related.
Thank you.
You're welcome. All right, thank you all. We'll talk soon. Bye.